charged with theft of a firearm worth less than $2,500.
You're talking about stuff that...
Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How does the FBI find people? And people is misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
I object.
What more do you need to see? Because he's the guy.
Hello. Welcome to the Court of Public Opinion. I am the Recovery Addict. I'm late, but I slept. I didn't say I slept poorly, actually, so I slept. Good morning. Welcome. Just trying to get everything squared away here. We're late. We're going to be jumping back to trial, which I thought was going to start this afternoon, which lucky for us does not. It's already started. So we're going to jump back and get caught up on the bad neighbor trial, which is about to begin. But of course, we have to do a couple things. Happy Friday, first of all. No Pats Friday. I think I had to get it live right when I realized I was late because I wasn't ready, literally, in that regard. So we're in shorts today. Good morning. For those that are wondering, it is beautiful outside. It's absolutely beautiful. I can see the mountains. The sun is rising. We're going to be to court in just a minute, but first we have to say good morning, welcome, and I think we owe something. Who do we owe for starting this whole process? Is that Krista? Let's see. Let me pop out chat here really quickly. I think it's Krista who on the internet this morning. I've got a noise clipping. How did I get a noise gate turned on over the... Let's see. There we go. Krista, congratulations. You have won the internet. Pardon me while I just turn off my noise gate. Oh, that's so much better. Ooh, that was bugging me. All right. Congratulations, you've won the internet. It's all yours to take care of, my friend. You've done it before. You can do it again. You're raw, Krista. You're gonna do fine today. You're gonna be fine. Sherry. It's a family show. All right. Quickly, if we can do the birthday songs. I know we've got a couple people who have a birthday either today or over the weekend. We're gonna sing to them. Then we're gonna start court, get caught up on all that the closings, because I believe we're finishing the defense case in the bad neighbor trial, and they should have closings today. You could sing happy birthday to my grandson who's being born today, currently at the hospital waiting for him to arrive. His name's going to be AJ. Let's add AJ to we have never sung on some of these. It's a misnomer, really. I mean, we sing on the anniversary of people's birthday, but this would be the first time we've actually sung on their birthday. Candace, I think that's wonderful. So we'll definitely add AJ to the list, and that goes with all these other wonderful people, by the way. Sharon, who's our mod, thank you very much, Sharon. Champ, Margaret, Fanny's grandpa, Emmy, Brendan, Jessica, Catherine, and another Jessica, and AJ. We're going to add AJ to that list. So let me find the birthday song. There it is. All right, sing with me if you will. Deep breath, project your voice to the back of the room and blend with your neighbors. Warm up with me if you will. La 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 la. There we go. All right, dancers at the ready. Here we go. Make sure we add AJ. We're going to split this up. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Sharon, Champ, Margaret, Fanny's grandpa, and Emmy. Happy birthday to you. So we've sung up to Emmy. We're going to do Brandon, Jessica, Catherine, another Jessica, and AJ. It might be the same Jessica. You might be double dipping Jessica, getting to sing twice in the same verse. It's all right. It's your birthday. We'll let you get away with it. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Jessica, Catherine, Jessica, and baby AJ. Happy birthday to you. To everyone who is celebrating a birthday today or having their first day today in the case of AJ. Thank you very much. We are so excited that you can celebrate with us. We realize there are a million places you could be, a million people you could be with, and you being here with us makes it all the more betteristical. And hopefully we can make your day more special-istical. I don't know if we can what word we can make up that makes your day better, but we'll try. Congratulations to everyone who had a birthday. Thank you very much, Sharon. Happy birthday as well. Wonderful mod who makes this all possible for everybody by keeping track of the birthdays in the morning. With that, we effectively have started the day appropriately. If you didn't know, I'm the sort of person that if I ever see people singing happy birthday at a restaurant, I just join in. I don't care if I don't know them. If they're across I think everyone deserves to be sung to on their birthday. So happy birthday. Thank you. Most of you, I'm still salty about my pancake denial. Help yourself to pancakes at Denny's or Waffle House or Village Inn or anywhere else you can get free pancakes. If you can talk them into free pancakes, I would do it today and use birthday as an excuse. That being said, we are going to jump to court in the I almost said salty, in the bad neighbor trial. Let's see. Ready? Where's that camera? There we are. Let's see, and I need to change out. The audio is terrible. So we're going to make it, first and foremost, we're going to go stereo. Hold tight. Or I guess more appropriately say mono. Boom, like that. Now I need the counter. I think we're at 81, and it's the Cursey counter, which is cursive. Is that it? There we go. We're at 81. The two counts are almost identical. We're at 85 on the anybody count and 81 on the cursive count this morning as we start off the day. Sharon, thanks for the kind words. The podcast last night was a blast. If you missed it, please watch it on the replay. Give it a thumbs up. Leave it a kind comment about how well I did and where WeatherWatch has room for improvement. That would, I'm just kidding. He did such a good job. Amazing podcast host. I would say co-host, but he's the host and I'm the co-host.
Court's now in session. Your Honor, Robert W. Hodges presiding.
Have a seat, everybody.
Kaylee, good luck to you. No, it's nerve-wracking.
I've shown the defense the list of juror numbers in the sheets I'm going to give them. Have you guys looked at them? They're up here. Take a look at them.
Everyone look at the jury papers.
So I'm going to give them their numbers.
And take away their names.
Now, I'm going to have Tracy, you deliver the numbers to them. I'm going to let them know that from here on out, I'm going to refer to them by number.
Judge, before the jury comes back, since the state and defense have arrested, I'd like to review the motion for judgment.
Yeah, I didn't forget. Just give me a second.
That was a request to renew the motion for judgment of acquittal.
No.
Which is not going to happen, I don't think. The light most favorable to the state, I don't think the judge could dismiss this case at this point. It has to go to the jury. There's enough for them to
starts to bring them out, send them back.
We could skip jury instructions and go straight to the closing, but we've missed all the jury instructions.
Has everyone looked at the instructions?
Yes, sir.
Is there any objections by anybody regarding the instructions?
No, Your Honor.
Okay. By the way, we're back on the record. State of Florida versus Susan Lorincz, 23 CF2236. Is it possible I can maybe do this another time?
Yeah, I just wanted to.
Okay. Yeah.
Can I?
Yeah, maybe
somebody
like,
just wanted to talk to him, said, Judge, are you aware that your car warranty has expired?
23 CF2236. So, everyone's looked at the instructions, is that correct?
Yes, sir.
Yes, sir.
Does the state have any objections?
No, Your Honor.
Any additions?
No, Your Honor.
Does the defense have any objections?
No, sir.
Any additions?
No, Your Honor.
You
Okay.
almost said addiction.
So I'm going to read to them in the order that we previously said. So the last thing I read will be the justifiable use of deadly force instruction.
Give me just a second. We're going to have it. I'll get this
And
going.
then I'll read
at
to
high
them
speed.
the closing
1.25.
argument instruction. So, Mr. Buxman, you're giving the closing argument?
I am, Your Honor.
Ms. Sizemore, you're giving the closing argument?
Yes, sir. I would ask that we take a short break after Mr. Buxman is finished, just so I can set up my stuff.
Yeah, no problem. We'll take a break after Mr. Buxman finishes.
I'm so glad they actually started in the morning, not the afternoon, like the judge said, because that fixes our problem with TELUS overlap.
I'd just like to renew the motion for judgment of acquittal on the same grounds.
All right, Ms. Watson, what is the argument you want to make?
Judge, there's no additional argument, just the argument that I made previously.
Sorry, I can't hear you.
There's no additional argument, just the arguments that were previously made.
Okay.
And it was
I
denied.
remember the arguments that were made. I reviewed the case law you submitted. I'm going to deny the motion for judgment of acquittal on the same grounds I denied it at the middle of the trial.
Yes, sir.
All right, thank you.
Amanda, is it Florentin? Welcome to the gallery. Brand new member. She's one of us now. Let her know nicely in a kind way that she can never leave now that she's through the door. Welcome. It's okay, you'll love it here. Thank you, Amanda.
So just listen to, before we bring him back, I'm going to bring him back. I'm going to go over it with him as I always do, whether anyone has influenced them or they've spoken to anybody. I'm going to explain to them the numbering system, and then I'll read the instructions. When we're done with everything, then I will excuse the two alternates. However, I'm instructing everyone not to have any contact whatsoever with the alternates. Please don't speak to them. Please keep them in the same manner they were before. In other words, don't acknowledge them. I'm just going to excuse them from the courtroom. I'm going to instruct everyone in the courtroom not to have any contact whatsoever with the alternates. Don't ask them a single question, okay? I'm going to send them home and instruct the alternates not to look up anything about the case or discuss anything about the case until they've heard that the trial is over, because there's always a possibility an alternate could be used, brought back into deliberation. So that's why I'm instructing everybody. An alternate, just so you know, if something happens to a juror in deliberations, the alternate could be brought back in. But if someone talks to that person, then I can't bring the alternate back in. So I'm instructing everyone to leave the alternates alone. We'll get them back to their cars and then let them go home, okay?
Yes, sir.
All right.
Validate that
Bring it back,
parking
please.
as well. Bradley Bouquet, whoop, whoop. 9 months. Thank you very much.
For the record, the defendant is dressed in civilian attire as always, and not handcuffed.
That's correct. She is here and present. Thank you.
No visible restraints, defending the civilian attire, even though she is in custody. We are catching up. I think we'll be fine on the time frame. We've got. I think this will work out perfectly. And I apologize for being late. And I found a channel that is interlaced so poorly that anytime somebody walks, it looks like the Matrix. It's nuts. It's crazy. How could anyone watch that? I mean, the Matrix, I guess, was a good show or something, but I didn't see it. Oh, sorry. Let's, Oh, you weren't seeing anything anyway, were you? Goodness.
Now, let's take a pause from June 2nd. You heard some information about the door jam.
Okay, I've got all sorts of issues going on. Hold tight. I think we're going to skip to the jury instructions, just to the end of the jury instructions, because that's the...
Read that paragraph. If you find at the time of the alleged manslaughter by use of a firearm, Susan Lorincz knew that Ajika Owens had committed an act or acts of violence, you may consider that fact in determining whether Susan Lorincz reasonably believed it was necessary for her to use deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capabilities of Susan Lorincz and Ajika Owens. Both the state and defendant have now rested their case. The attorneys will now present their final arguments.
Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. I just want to remind you that I will be giving each of you a copy of these instructions to take back with you when you deliberate. Mr. Buxman. Yes, sir.
May I have the access to the TV runner?
You didn't say please, sir.
You ready to go? You ready for it?
Yes, sir. This case basically requires you as a jury to answer one question. Was it reasonable to shoot through a closed, locked, deadbolted metal door at someone who's banging and yelling on the other side? That's the ultimate question in this case. The evidence in this case that you've heard for the past several days has proven beyond any reasonable doubt that the defendant's actions were not reasonable that night. The judge just read the law to you that's applicable to this case, and it is that law that guides your decision in this case. It is that law that you must follow. It is that law that we as a society have agreed to live by, and you, by taking your oath as a juror, have agreed to follow. And that's the law that should guide your entire analysis in this case. As you heard, the defendant is charged with one count of manslaughter. And in order to prove manslaughter, the state has to prove the following two elements beyond a reasonable doubt. Number one, Ajika Owens is dead. That is not in dispute. That was agreed by the parties. I'm not going to spend any more time on that. That's been proven beyond any doubt. Two, the state has to prove either that Susan Lorincz intentionally committed an act or acts that caused the death of Ajika Owens, or B, the death of Ajika Owens was caused by the culpable negligence of Susan Lorincz. The state only has to prove A or B, but the evidence in this case has proven beyond any reasonable doubt both of those. Let's talk about A first. That the defendant intentionally committed an act or acts that caused the death of Ajika Owens. There is no question in this case that the defendant was the one that fired the gun that shot and killed Ms. Owens. She was the only one in the apartment that night. You heard crime scene investigator Catherine Medina, who processed the inside of her apartment, went into that bedroom and found that .380 Remington firearm in the trash can beneath that .22 Ruger firearm. Catherine Medina also found the spent shell casing that was found on the kitchen counter. Dr. Norford, the medical examiner, removed the projectile from Ms. Owens' body. And you heard from Florida Department of Law Enforcement analyst Jamie Williamson, who said she took that firearm that was found in the defendant's residence, compared it to the spent shell casing found in the kitchen, and determined that that casing was fired from the defendant's gun. She also examined that projectile recovered from Ms. Owens' body and compared it to the .380 Remington firearm, the defendant's, and found that the projectile in Ms. Owens' body was fired by the defendant's gun. Finally, the defendant admitted during her interview that she was the one that fired that gun. She also admitted that the act of pulling that trigger and firing that gun was an intentional act. It wasn't an accidental situation. It wasn't a situation where she slipped and fell and the gun accidentally went off and shot through the door and struck Ms. Owens. That's not what we have here. She intentionally fired it. There's no doubt the defendant intentionally committed an act which caused the death of Ajika Owens.
Thank you, little B.
And we also know that Ms. Owens died as a result of that gunshot wound.
Catsy, thank you so much.
The state's proven this beyond any reasonable doubt. You heard the judge read an instruction. You may be back there thinking, well, what if the defendant didn't intend to kill Ms. Owens? Well, the judge has told you that that is not an element, that's not a requirement for the state to prove in a manslaughter charge that the defendant intended to kill Ms. Owens. She's not charged with first-degree premeditated murder, which would require an intent to kill. She's charged with manslaughter. And the judge told you that in order to convict of manslaughter, it's not necessary for the state to prove the defendant had an intent to cause the death. We'll get into what the state only has to show that the act was not merely negligent, justified, or excusable, and we're going to get to those terms in a few minutes. Because Part A of element 2 has been proven beyond any reasonable doubt. There's no even need to get to B. However, the evidence has also proven that the death of Ajika Owens was also caused by the culpable negligence of the defendant. The judge read to you a long instruction about culpable negligence, told you that each of us has a duty to act reasonably towards others. In order for negligence to be culpable, it must be gross and flagrant. It has to show a reckless disregard for human life or the safety of people exposed to its dangerous effects. It has to be committed with an utter disregard for the safety of others. The evidence has proven that the defendant did act with utter disregard for the life of others. She pointed a loaded firearm towards a door, towards a person that she knew was there on the opposite side of the door, and intentionally pulled the trigger. That shows a reckless disregard for human life. It's an act which she must have known or reasonably known would cause death or serious bodily injury if that projectile struck somebody. The evidence has proven beyond any reasonable doubt that the act of firing that gun constitutes culpable negligence. The crime of manslaughter has been proven beyond any doubt whatsoever, ladies and gentlemen. The question in this case lies with whether or not she was allowed to shoot and kill Miss Owens under these circumstances. The law says that in certain circumstances, a person cannot be held liable or responsible for shooting another person. And the first situation is if the killing was excusable. The judge read to you this instruction a few minutes ago. I'm not going to read the whole thing. But in order for a killing to be excusable, the killing in each of those 3 situations has to be committed by accident. And we've already discussed that this was not an accidental discharge. It's not a situation where she was playing with the gun and it accidentally went off and shot through the door or she dropped it. This was an intentional act. So excusable homicide is not relevant in this case. Another way in which a person could not be held legally responsible for killing another is if the killing was justifiable. You heard Judge Hodges read a few minutes ago that the killing of a human being is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant or commit a felony in any dwelling house in which the defendant was at the time of the killing. That is the general instruction on justifiable homicide. The judge read to you a longer, more detailed instruction, which is what I'm going to go over now. Judge Hodges explained to you that if the defendant was in a dwelling or residence in which she had a right to be, she had no duty to retreat and had the right to stand her ground and use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent either A, imminent death or great bodily harm to herself, or the imminent commission of a burglary, murder, or aggravated battery against herself. That first sentence there, if she was in a dwelling or residence in which she had the right to be, she had no duty to retreat. That applies in this case, ladies and gentlemen. The defendant was in her own home. The law accounts for that because people do have a right to be in their own home and be safe in their own home. That applies in this case. The law does not require her to jump out the back window and retreat in order to avoid this because she is in her own home. She doesn't have to do that in order to claim that she acted in self-defense. Now, her actions inside of her house and what she does during this period of time is relevant to look at the reasonableness of her fear and the reasonableness of her actions and decision in making and shooting. But she is not required to try to jump out a window to avoid this before she can claim self-defense. The crux of this case, ladies and gentlemen, is whether at the time she fired her gun at that closed, locked, deadbolted door, did she reasonably believe that her conduct was necessary to prevent imminent death or great bodily harm against her, or the imminent commission of burglary, murder, or aggravated battery. The instructions that the judge read to you gives you an explanation of what burglary, murder, or aggravated battery mean legally. And I'm going to go through those later on. He read them to you, so I'm not going to go over them again right now, but we're going to address those later on. The judge also explained to you that in deciding whether the defendant was justified in using deadly force in firing that gun, you have to consider the circumstances under which she was surrounded at the time she chose to fire. Judge Hodges explained to you that the danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real the defendant actually believed the use of deadly force was necessary. Well, what does it mean by the danger need not be actual? Well, if the bailiff here and I are getting into an argument and I start getting heated and I start walking towards her and I pull out a gun and she pulls out a gun and shoots and kills me, but my gun was a fake gun, my danger to her wasn't actual. But all the circumstances surrounding it made her think that it was. So the actual danger need not be actual, but the defendant actually had to reasonably believe that the use of deadly force was necessary to prevent an imminent harm to herself. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. The standard by which you review this is based on whether a reasonably cautious and prudent person under the same circumstances the defendant would have felt the danger was necessary. You take a normal, average, everyday person and ask yourself, would that normal, average, everyday person under these circumstances have believed that it was necessary to use deadly force to prevent the imminent harm to themselves or the imminent commission of a burglary, murder, or aggravated battery? I've used the word imminent many times because that's in all of these definitions, and that's very important. It's not that something bad could happen in the future or something may have. That something bad has to be imminent, immediate, about to happen. So let's start with whether or not the defendant reasonably believed that her firing the gun was necessary to prevent imminent death or great bodily harm to herself. What were the circumstances she found herself in at the time she chose to pull that trigger? Because that's the relevant time. When she makes that decision to pull that trigger, what are the circumstances surrounding her? That's what the law focuses on. Taking a step back, though, we know that there have been past issues between the defendant and Ms. Owens. We've heard about a couple issues during the testimony and the evidence that they had some conflict in the past. That information is relevant to you, could be relevant to you, to consider, because those past contacts between the defendant and Ms. Owens could factor into the reasonableness of her decision in pulling the trigger. They may not. But the judge read to you, if you find a defendant who, because of threats or prior difficulties with Ms. Owens, had reasonable grounds to believe she was in danger of death or great bodily harm at the hands of Ms. Owens, you may consider this fact in determining whether the defendant's actions were those of a reasonable person. I want to talk a little bit about those prior issues. We know that these prior run-ins were the result of the defendant acting out or doing something towards the victim's children, Isaac and Israel. And at the time, we heard that Isaac was about 12 years old, Israel was about 9 or 10 years old. We heard that the defendant complained about the children, complained about them playing in this field, this open lot next door to her house. You heard that these children would play in that open field. They played football, they played some bottle game and some running around, what kids do. They weren't breaking into cars, they weren't vandalizing.
So ruled. Go ahead.
They weren't causing problems, vandalizing things, they were playing. And you heard from Frank Colon, who told you he was often out there playing with the children regularly to make sure they behaved. But as children do when they're playing, especially in groups, the children got loud. The children yelled and screamed and played to do what kids do. The defendant, the evidence has shown, didn't like that. She told the detectives in the interview she works from home, the loud noises interfered with that ability, she didn't like it. She complained to Charles Gabbard, her landlord, and Charles Gabbard, in response, in order to pacify her and appease her, got some no trespassing signs, those little signs that you get from Lowe's or Home Depot, and put them in the ground. She complained to the police about the children when she would call, complaining that the children were too close to her property or trespassing on her property or leaving things on her property, toys, and that they were loud. It's important to note that Charles Gabbard owns the property the defendant lived in, but he does not own that open field where the children played. Charles Gabbard has no ability to tell those children don't play there, or tell the children to be quiet, and neither did the police. You heard on two prior occasions that there were some prior difficulties between the defendant and Miss Owens. You heard on one occasion, which happened February 25th of 2022, about 16 months prior to the shooting, that the defendant was again upset about the children playing, being loud, doing what they were doing. And you heard from London Remy, the 13-year-old girl that testified on the first day of this trial, that Miss Owens walked over to the defendant's area, and there was an argument between the defendant and Miss Owens. Miss Owens went over there to tell the defendant to stop yelling and treating her kids the way that she was. There was an argument, and Miss Owens pulled the no trespassing sign out and tossed it at the defendant as she was walking away. You heard London Remy talk to you about that. And she explained and even demonstrated how Miss Owens took the sign and tossed it as she was walking away. And that sign hit the defendant in the leg. Was that the proper way of probably handling the situation by Miss Owens? Probably not. But what's important to know is there were no punches thrown. Miss Owens didn't run up and attack the defendant, didn't punch her in the head, knock her down, kick her, didn't, bust into her house or anything like that. Miss Owens said what she had to say, tossed the sign, and walked away, leaving the confrontation. The defendant called 911, the emergency line. The officers came out, talked to everybody, and no arrests were made. On another occasion, December 22nd of 2022, about 6 months before this crime, the defendant was again angry at the children for being loud. Obviously, the children told their mother because, again, Miss Owens came over to the defendant's property and told the defendant not to yell at the children. We heard from Deputy Kinsey, who spoke with Miss Owens, and Miss Owens told Deputy Kinsey, I walked over there with my child and wanted to talk to the defendant and deal with the situation. According to the defendant, the victim told her that if you yell at my kids again, I'm going to drag you out and beat your butt, basically.
Ooh, spared us a counter.
But remember in the defendant's second interview that you heard with the detectives, she was specifically asked if she remembered any kind of threats like that. And the defendant said she didn't remember anything. So either Miss Owens never made such a statement, or the statement wasn't so significant such that the defendant even remembered it to talk to the detectives about it when specifically asked. And we also know that the defendant, moving ahead to the night of the shooting, the defendant tells the detectives that Miss Owens came over and said, I'm going to effing kill you, over and over again. No one else heard that. You heard from Jared Gardner, you heard from Ariel Rodriguez, who were right there. They said she never said that. So back to February of 2023. We know that Miss Owens was upset about how the defendant was talking or treating her children. Miss Owens walks over to the defendant's property. They have this argument, disagreement, whatever you want to call it. There's no violence. There's no punches thrown. Miss Owens doesn't knock the defendant down and kick her and beat her. She doesn't try to break into her house, shatter her sliding glass door to get to her, nothing. It's a verbal argument, and the verbal argument ends when Miss Owens walks away from the situation and goes back to her house.
Vertical argument?
The defendant again calls 911. The police come out. They interview everybody. No arrests are made. As I said earlier, you can consider these prior difficulties between the two in determining whether or not they contributed to the defendant's decision to fire that gun that night.
That helps
June
the
2nd,
defense.
2023. I submit to you that these two episodes, one of which happened about 16 months before the shooting, one happened about 6 months or so before the shooting, involved no violence except for the tossing of a sign, a flimsy Lowe's no trespassing sign. They didn't involve the defendant or the victim trying to break into the defendant's house. Didn't involve Miss Owens beating the defendant up or causing her any physical injuries. And were resolved when Miss Owens walked away from the confrontation. Now, it's interesting in her interview, in the defendant's interview, that she described an incident that happened about 2 months before the shooting on June 2nd, after the sign throwing incident, after the second incident that happened in December of 2022. She described an incident that happened about 2 months before the shooting. Now, the defendant in her interview tried to explain how this sign throwing incident and this other incident caused her such terror of Miss Owens, such fear, such panic, because Miss Owens was so violent that contributed to her, the reasonableness and why she decided to fire the gun. But let's talk about what the defendant said in her interview about the incident that happened 2 months prior to the shooting, after these other things. She's talking to the detectives about the sign throwing, or about this incident that happened 2 months before, and she tells the detectives, and one time she was talking to the neighbors, meaning the defendant, or meaning Miss Owens, and she said, "Oh, that bitch over there is crazy, you know. I'm not going, sorry. I walked over. I said, what is your problem?" And she just went on a tirade. She tells the detective, "I walked over and said, what is your problem?" The defendant admitted that she was the one that walked over and confronted Miss Owens about Miss Owens telling a neighbor that the defendant was a crazy bitch. And she told the detectives further that she was actually over by Miss Owens' driveway when she confronted Miss Owens. Does that sound like the actions of someone who was so terrified because somebody tossed in a trespassing sign and someone came over and had an argument with her earlier? Does that sound like somebody who's so afraid of this woman that she's going to walk up to this woman, confront her in her own driveway? Or does that sound like someone who is angry at Miss Owens and has no problem initiating confrontation?
My DoorDash is almost here. I'll be right back.
The defendant also explained that during this same incident, two months or so before the shooting, that Miss Owens accused her, the defendant, of using racial slurs towards her children. The defendant during an interview explained, "Look, I told her I didn't do that. She kept insisting I did." And the defendant said, "I eventually just said I'm sorry to diffuse the situation." There is probably nothing more infuriating to an African American woman.
Objection, improper argument.
So overruled.
There is probably nothing more infuriating to an African American woman for someone to believe that someone used a racial slur towards her children. But what does Miss Owens do when she thinks this is what happened? She doesn't go over and attack the defendant, she doesn't go over and beat the defendant up. She doesn't go and attack Miss Lorincz, push her down, say, "This is what you told my children." She goes and she has an argument. And Miss Owens doesn't resort to violence. Miss Owens walks away. Miss Owens, if she wanted to, had every ability to attack the defendant for that. But she didn't. She had every ability because even then, there wasn't a closed, locked, deadbolted mental door between them. Despite not having that barrier, Miss Owens did not do anything violent towards the defendant. Instead, she walked away without incident. Which brings us to June 2nd, 2023, the day of the shooting. We saw videos taken from the defendant's cell phone during the couple hours before the shooting happened. They showed the children playing in that open field. You saw Frank Cologne out with the children one time in one of those videos. And in one of those videos, taken at 8:49:51, we see Israel waving past the trespassing signs on her property, waving at her. Once again, the defendant was angry because the children were being loud and it was bothering her, and Israel went past the no trespassing sign. And you heard from Muriel Rodriguez, who said, yes, in fact, that night, Israel did go past the no trespassing sign. We saw that in the video we just looked at. We heard from the defendant's 911 call in the interview with the detectives that there was some altercation between the defendant and Miss Owens' children. It involved a tablet, roller skates being thrown, an umbrella being shaken, something. The facts of that altercation really aren't important or relevant. What's relevant is that that is the catalyst, that is what causes the children to go and tell Ms. Owens. And that's what causes Ms. Owens to come over and once again deal with an issue regarding the defendant and her children. We heard from the 911 call that the defendant made, the first 911 call before the shooting, and she acknowledged there was an issue with the children. She acknowledged that she threw some roller skates. She acknowledged and told the 911 operator that the child accused her of stealing the iPad. We heard in the 911 call that, in the interview, that there was something involving shaking an umbrella as well. So we know that the defendant got into some sort of argument or something with the children, which caused the children to go talk to Miss Owens, their mother, and causes Miss Owens to come over to deal with it. You heard from Jesse Newbanks, the Marion County Sheriff's Office digital forensic examiner who examined the defendant's cell phone. And going into the logs of the cell phone, we know that the defendant first made that first 911 call that we heard at 8:54:09 p.m. And you heard her on that call. That was played earlier. You heard her. She was angry about the children trespassing, angry about that 9-year-old stepping onto her property, angry about the children leaving things in her area. She was angry the kids were being noisy. And she admitted to throwing the roller skate like we saw in the photo a few minutes ago. She told the 911 operator that she was sick of the children. Her words were, "They are bothering me. They won't effing stop." She wasn't afraid. She was angry. You heard the tone of that 911 call. The 911 call, an operator asked, "Are you in danger?" And she said, "No, I locked my door." She locked her metal door. We know from her 911 call, the main lock was engaged. We know from her interview with the detectives, the deadbolt was engaged. So at this time, she is behind a closed, locked, deadbolted metal door, standard metal door, about 1 3/4 inches thick. She's behind that.
I was going to say, are they going to beat on the door for a demonstration? Defense should. As hard as they possibly want. You can't beat on the podium, but I would beat on the door until it knocked right off the support or tipped over.
Now, let's take a pause from June 2nd. You heard some information about the door jamb having some prior damage to it. And we saw photos, the state introduced photos of that door jamb and then the prior damage.
With the cosmetic repair.
We heard from the landlord, Charles Gabbard, who said, yes, that door about a couple months earlier had some damage to it. I went and repaired it. He told you he replaced the strike plate of the lock. He replaced the strike plate for the deadbolt. He drilled those things into the door frame, and it was secure. He used some wood putty to further secure it, and the only thing that was left was some cosmetic damage that didn't affect the integrity or the stability or the durability of that door. He told you that when he left, the defendant was content with his repairs, except for the cosmetic damage, which he said, I'm going to come back and make it look pretty. But that door was secure. There was no concern at all that that door wasn't going to hold up if someone banged on it.
You put bigger screws
So we talked
in.
about the first 911 call was made at 8:54:09 p.m. And based on Jesse Newbanks' analysis, that call lasted 4 minutes and 55 seconds, which means she hung that phone up at 8:59:04. At 9:01 and 37 seconds is when the data on her phone says she picked up the phone again to call 911 after the shooting happened. So whatever happened with Ms. Owens coming to the door, banging on the door, the defendant going in to her bedroom, getting the gun, coming out, aiming at the door, shooting, and then her getting her cell phone and making a call, took 2 minutes and 33 seconds. Not the 10 minutes like she told the detectives. 2 minutes and 33 seconds. So again, the evidence has shown that before she makes the second 911 call, Ms. Owens walks from her house across the street to the defendant's house to deal with the situation involving her children. Witnesses said she walked over there with purpose. She was mad, no question.
Someone had slammed it before?
Jared Gardner told you that he heard Miss Owens say, after she's banged on the door, something to the effect of, come out here, bitch, or bitch, open the door, something to that effect. Sheriff Gardner told you he never heard Miss Owens say anything like, I'm going to effing kill you, I'm going to break down your door, I'm going to go in your house. He didn't hear anything like that, because those statements weren't made. He heard Miss Owens tell the defendant, come outside. You heard from Uriel Rodriguez, 12-year-old Uriel Rodriguez, the second witness we called. He told you he saw Miss Owens walk across the street, saw her walking with a purpose, saw that she was angry, it was clear how she was walking, saw she didn't have anything in her hands. He heard Miss Owens say, come out. And he said she used the B word and the F word, consistent with what Jared Gardner said. So he too hears Miss Owens say, come out, bitch.
He's fine saying the B word.
Rodriguez said he never heard Miss Owens threaten the defendant, say, I'm going to F and kill you, I'm going to bust in your house, anything like that. It was come out. Ms. Owens made it clear to the defendant that she wanted the defendant to come out and deal with this situation. If Ms. Owens wanted to get into that house, all she had to do was take something from the patio, that little Santa thing that was sitting there, throw it through the sliding glass door, shatter the door, and get in there. She didn't do any of that, because her goal was not to get in the house. It was to get the defendant to come out and deal with the situation with her children. Even in the defendant's interview with the detectives, she was asked what was the first thing that came out of Miss Owens' mouth. And the defendant said, Miss Owens first said, I want to speak to you because you're talking to my sons. I don't like the way you're talking to my sons. First thing out of her mouth deals with her sons. First thing out of her mouth is not, I'm going to bust in your house and I'm going to kill you. It's, I want to talk to you about my sons, just like the last times. You heard from Yvonne Costa, who's the neighbor, had the joining wall to the defendant's apartment. She told you that she heard arguing, loud arguing, and then she heard a door slam. Clearly, this was the defendant slamming her door after she was arguing with the children, because Yvonne Costa said a few minutes later is when she hears the pounding. And the pounding was loud. There's no doubt about that. It was loud enough to shake the wall between the two of them that they share, and maybe even rattle a mirror. It was loud. But it wasn't banging hard enough to damage the door. There's no dents. There's no major problems with the door. No damage to the doorknob as if someone was trying to beat on it and break the doorknob off to get in there. She was banging hard like law enforcement officers do when they come to a door and say, Marion County Sheriff's Office. And in fact, the defendant actually told the detectives she initially thought it might be the law enforcement coming.
That's what they do right before they come through the door and get you.
And knew they were coming. She knew they were coming before she fired the shot. Everyone then, after the banging, hears the shot. You heard the interviews the defendant gave and the 911 calls. The defendant never said that Miss Owens was rattling her doorknob, shaking the doorknob as if she was trying to get in. She was specifically asked during the second interview, did she ever try to open that sliding glass door or open the door handle or anything like that, or was it just pounding? The defendant's answer was, I just remember her pounding and pounding. You also heard in the interview that the defendant gave that the sliding glass door was further secured by a wooden stick in the track, so the door couldn't be opened. It was locked, the door couldn't be opened because of that wooden stick. The defendant never told the detectives during the interviews that Miss Owens was trying to open that sliding glass door, that she was banging or jiggling on the doorknob trying to get in. Never told them that she was trying to break her window or anything like that. Rather than wait for law enforcement to arrive, because she knew they were coming, because she called and they told her that law enforcement was coming, she went into her bedroom and grabbed her gun. She doesn't grab her phone, which she just had in her hand 2 minutes earlier, to call 911 again. She goes in the bedroom and grabs her gun. She goes back into the family room. She approaches the door to the point where she says she reached that kitchen table. She doesn't fire a warning shot through the door or in the air, into the ground, anything like that. We heard her in her first interview say she never intended to kill Miss Owens. Well, look at the placement of the shot that she fired. She took aim, she leveled the gun at the door. She aimed directly where a person would be if the person was knocking on the door, at a height consistent with where Miss Owens would be, and pulled the trigger. She didn't fire over and over and over again. She didn't unload her magazine as if she was in a panic. She fired one controlled, precise round into the door at the exact place a person would be if they were knocking. Then she had the presence of mind to go back into her bedroom, put that .380 Remington back in the trash can, underneath the .22 caliber Ruger that was found, because remember, CSI Medina found the .380 gun, the gun that used to fire the bullet in this case, beneath the .22 caliber Ruger, the little plinker. And then she has the presence to call 911. So now that we know what the evidence has shown, let's go back to the instructions that we looked at earlier. The circumstances that she found herself in when she fired that round were that she was angry at Miss Owens' children, such that she called 911 on the children. That an angry mother was banging on her door, yelling at her to come outside. That she's behind a closed, locked, deadbolted metal door, and she knows law enforcement is on the way. She goes into her bedroom, she grabs her gun, walks back to the living room, walks towards the door, fires one precise round in the exact location where a person would be. Those are the circumstances by which she was surrounded when she made that decision to pull the trigger, at the time she decided to use deadly force. There was no imminent danger whatsoever when she fired that gun. Miss Owens had not broken down the door. She hadn't gained access to her house. She hadn't shattered the sliding glass door to get in. Miss Owens was banging on the door, telling the defendant to come out. A belief that there was an immediate or imminent danger such that deadly force was necessary at that time was simply unreasonable, because there was no imminent danger. And that word imminent is very important. It's included in the law for a reason. In order for the defendant to be allowed to use deadly force, that threat to her life must be imminent. It had to be ready to happen. It had to be staring her in the face, such as she had to act at that moment to protect her life. If Miss Owens would somehow have managed to bust through this locked, deadbolted metal door, entered her house, and started coming at her, the defendant may have had a right to shoot, because that danger would have then been imminent. But that's not the situation we have here. We talked about Part A, imminent death or great bodily harm to herself. She would also have the right to use deadly force if she needed to do so to prevent the imminent commission of a burglary, murder, or aggravated battery against herself. Murder is defined as the intentional, unlawful killing of another by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Again, there's no evidence to support that at the time the defendant fired that gun, that Miss Owens was about to murder her. Miss Owens had no ability whatsoever to even get into that house, to even try to cause her harm. There is the secure, locked, deadbolted metal door. It's not a situation where Miss Owens was charging at the defendant with a gun, a bat, a knife, something like that, and she had to resort to use deadly force. That's not our situation. Similarly, the crime of aggravated battery is an intentionally touching or striking another with a deadly weapon, or intentionally or knowingly causing great bodily harm, permanent disability, or permanent disfigurement. Just like the previous explanation, Miss Owens, at the time she was shot, had no ability whatsoever to even get into that house. It also is interesting to know that at no time during the interview does she claim to think that Miss Owens had any kind of a weapon. There's no evidence to support that Miss Owens was in the process of committing an aggravated battery or about to cause her imminent, immediate harm when she fired that gun. Let's talk about burglary. The defendant would be allowed to use deadly force to prevent the imminent commission of a burglary upon herself. Well, what is burglary? Burglary is entering a structure owned by or in the possession of another with the intent to commit a crime therein. And the crime can't be burglary or trespass. The judge also read you the definition of structure. It means any building of any kind, temporary or permanent, that has a roof over its head and the enclosed space of ground and outbuildings immediately surrounding the structure. The enclosure need not be continuous, as it may have an ungated opening for entering and exiting. Based on the law, there is no doubt the inside of the defendant's house is a structure. This is a situation where Ms. Owens is standing on the other side of the door yelling at the defendant to come outside. There's no evidence whatsoever that Ms. Owens was trying to enter her residence. She's not jiggling the doorknob. She's not, shattering the sliding glass door or anything like that. There's no evidence that Ms. Owens said anything to indicate she was going to bust into her house.
Thank you, Joanne, for the super sticker.
No evidence that Ms. Owens was committing a burglary of getting into her house or trying to get into her house. Also included, though, in the definition of structure includes the enclosed space of ground and outbuildings immediately surrounding that structure. That would include the defendant's porch area. The evidence has shown that Ms. Owens walked onto her porch area, the defendant's porch area, to bang on that door.
So she entered the
structure. So Ms. Owens did enter that portion of the structure, that porch area.
That might be
But what's
key.
important about burglary is that second sentence up there in the first paragraph. Or the first sentence, I'm sorry. In order for something to be a burglary, the person would have to enter the structure with the intent to commit a crime. That's why the mailman or the Amazon delivery guy can come onto the porch and drop off a package and not be charged with burglary, because there's no intent to commit a crime.
Can you say she trespassed with the intent to trespass?
The crime that is intended to be committed cannot be burglary. Obviously, you can't use the charged crime with the intended crime to be the same, and it also can't be trespass.
You read my mind.
The crime has to be something other than Ms. Owens walking onto that porch, by law, by the law that we all have agreed to live by. That crime that intended to be committed to be a burglary could be theft, could be vandalism, could be some violent crime towards a person, but it cannot be simply walking onto that porch.
He's almost making the defense's case here. He has to be careful.
Well, Ms. Owens walked onto the porch,
Selena
therefore
thinks,
she intended to commit a trespass, therefore it's a burglary, therefore the defendant has the right to shoot. That would be legally incorrect. And that would be a miscarriage of justice. It's legally insufficient for that to constitute a burglary. In order for the defendant to have the right to shoot Ms. Owens, there has to be it has to be done to prevent the imminent, immediate, about to happen commission of a burglary. And that burglary would have to be that Ms. Owens came on the property with the intent to commit some crime. Ms. Owens came onto the property to have the defendant come out to discuss this issue. It's not a crime to bang on somebody's door. It's not a crime to yell. There is no evidence that she came over there with any other intent but to get the defendant to come out and talk. That's why Ms. Owens' actions don't constitute a burglary. The judge also read to you an instruction that Susan Lorincz is presumed to have held a reasonable fear of imminent peril, of death or great bodily harm to herself when using defensive force that was intended or likely to cause death or great bodily harm if these two things happen. The person against whom the defensive force was used, in this case Ms. Owens, she was the one that the force was used against, was in the process of unlawfully and forcefully entering or had unlawfully and forcibly entered a dwelling or residence, or if that person was attempting to remove another against that person's will from the dwelling. And the defendant knew or had reason to believe that the unlawful and forcible entry or the forcible act was occurring or had occurred. Notice what this instruction requires. The person was in the process of unlawfully and forcefully entering or had unlawfully and forcibly entered the residence. Not that the intruder may want to come in or could come in. The intruder has to be in the process of entering the residence or in the residence. We don't have that here. As we discussed, there's no evidence whatsoever that Ms. Owens was actually in the process of unlawfully or forcibly entering the house. The defendant is not entitled to any kind of presumption that she was in fear. Based on the law that we went over and the evidence and circumstances surrounding the defendant when she chose to fire that gun, which killed Ms. Owens, her actions were not reasonable, and she was not allowed to use deadly force legally, based on the law. Now, you heard from a crime scene expert, Joshua Wright, who explained where he thought the defendant was standing when she fired the gun in the house. You heard from a computer graphics gentleman who did the video that we saw and some of the photogrammetry information that was yesterday. And those representations relied heavily on what the defendant said happened, her own version of events. You also heard from Roy Bedard, who talked in generalities about how people make decisions in stressful situations. Ladies and gentlemen, none of that testimony sheds any light on the reasonableness of the defendant's decision or the imminence of the threat that she perceived. Ladies and gentlemen, because the evidence has proven beyond any reasonable doubt that the defendant's decision to use deadly force by pulling that trigger, and because her intentional act of firing through that door caused the death of Ajika Owens, we're asking you to find the defendant guilty of manslaughter with a firearm. Thank you.
Ladies and gentlemen, we're going to take a short break.
We're going to skip the
about
break.
10 minutes, and then we'll come back and hear the defense closing argument.
Big Sky, I got the email. Thank you very much. I'm reading it right now. All right, we're going to take a tiny break here. Well, we're not going to take a break. We're going to skip the break and come back with defense argument. There we go. Ready, set, here we go. We're back. Break's over. Ready for defense. Yes, my wife just came through the door when I thought I was home alone. Opened the door to the studio. I just about needed to have a wardrobe change. It scared me to death. She thought it was funny.
Welcome back, ladies and gentlemen. We will now hear from Ms. Sizemore.
May I please report?
Yes, ma'am.
Counsel? Good morning.
It's our last real go at the curse counter.
This case is about perception. The Constitution of our country embodies the right to be able to defend ourselves. And there's a wisdom in our laws that begins with this concept of perception. It's central to self-defense because the law protects that reasonable perception. The law demands that we assess the reasonableness of that perception, not from the comfort of a courtroom. But we have to take ourselves back to the perspective of the moment itself. The law requires each and every one of us to look at the circumstances that Susan Lorincz was facing on June 2nd of 2023. She was almost 59 years old. She was in her home where she lived alone, a troubled neighborhood, to say the least. It was nighttime. She was suffering from a multitude of medical conditions when she was startled by a barrage of screaming of profanities and banging on her door so hard that the walls were shaking in a cement block house. Now, the judge has gone over with us some of the law in this case, and it's very, very important, particularly when we are dealing with self-defense. And I know Mr. Buxman went over a little bit. I need to go over it with you, and this is the only opportunity that I have to speak with you, so just bear with me. In jury selection, the judge talked to us about this plea of not guilty and reasonable doubt. He sort of went over that instruction, and he gave it again, and there's a reason that it's one of the first instructions that we get. It's sort of the foundation of our system of justice. So what does it tell us? It tells us that Susan Lorincz has entered a plea of not guilty. This means you must presume or believe that she is innocent. So we start there. We start with the fact that she's innocent, and where does it go? Where does that presumption go? It stays with the defendant as to each material allegation in the information through each state of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. That's pretty powerful language for the protection of our liberties. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. We talked about this term reasonable doubt in jury selection. I'm not going to read the whole definition to you again. The judge gave it to you again. And it's very important. And what is reasonable doubt?
I might speed her up a little bit. She's a little bit slow, and I know she wants to take a full 2 hours.
It means you have to be sure. Really sure.
Krista, thank you so much for gifting 5 memberships.
The law says you
Appreciate
should
that.
only convict someone if you're convinced they're guilty beyond a reasonable doubt.
Krista's the
You
queen
should
of the
feel
rewatch
confident
crew,
in
by
your
the way.
decision without hesitation. So if there's something in the evidence that gives you pause, if you're back there and you're deliberating and you're thinking, man, she was an older woman. She had some medical issues. She did live alone. She had these prior run-ins with Adjika. I could see how she could be scared of her. And you're thinking, I did see the damage on that door. That's reasonable. I could see how she could be afraid that she was going to get through. If you're back there and you're pausing and you're hesitating, if you're wavering and vacillating, that's reasonable doubt. And if you have a reasonable doubt, you should find Ms. Lorincz not guilty, because that is what the law says. And each and every one of you took an oath to follow the law. So where do we look for reasonable doubt? It is to the evidence introduced in this trial, and to it alone. Only the evidence introduced in this trial and nothing else, that you are to look for that proof.
Okay.
It may arise from the evidence, the conflict in the evidence, or the lack of evidence. And if you have a reasonable doubt, you should find the defendant not guilty.
There it is.
Justifiable use or threatened use of deadly force. This is a very, very important jury instruction. You're going to get to work with this when you're deliberating. The laws in Florida give citizens the right to defend themselves when they are faced with imminent danger.
Florida has some of the best
Deadly
laws for
force
that in
means
the country.
force that
if
is
you want
likely to
defend
cause death or
yourself.
great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm. And the most important thing in this part of the jury instruction is where it says, for you to find the defendant guilty, the state must prove beyond a reasonable doubt that the defendant was not justified in using deadly force. So they not only have to prove to you that she committed this manslaughter, but they also have to prove to you beyond a reasonable doubt that she was not justified in using deadly force. Now, Mr. Buxman went over this, Judge Hodges read this to us, and there's a couple important parts of this jury instruction that we need to focus on. And one is, if Susan Lorincz was in a dwelling in which she had a right to be, she had no duty to retreat. If you remember during the trial, Mr. Smith had asked some of the witnesses, did Susan shoot from way back there by her bedroom? Did she shoot from behind that countertop or behind that kitchen? It doesn't matter, because she has no duty to retreat, and she can stand her ground when she is in her dwelling if she is faced with imminent danger. Another important part of this is if she reasonably believed. We do not judge Susan Lorincz with what we in this courtroom have experienced in life. It's not what I would do, or Mr. Buxman or Mr. Smith would do in that circumstance. It's what Susan Lorincz reasonably believed was necessary to prevent That's a very important word. Prevent. The law does not say that you have to wait to get punched or attacked before you can do something. That's not what it says. You can use deadly force to prevent someone from coming into your home and hurting you or attacking you. Because members of the jury, if someone who is on the outside of your door that is banging and pounding so hard wants to get in that house and they do, it is too late. There are way too many variables if someone actually gets inside. Your gun could jam. You could get rushed. You could fall, especially if you have medical conditions. So the law accounts for that. You can do what you need to do to prevent that from happening. What was Ms. Lorincz confronted with on that night when she had to make a split-second decision? We heard from Dr. Roy Bedard. He's a world-renowned use of force expert, trains law enforcement officers all over the country, and he talked to us about how someone reacts under stressful situations, these high-stakes decision-making. And he told us that when there's high consequences, you don't really know if the person on the other side of the door or the person that's confronting you is armed. Not just Susan Lorincz, but most people go to the fact that this person is armed, that they are a real threat. That's reasonable. And Susan Lorincz had no idea what Adjika Owens had on her. He told us that biologically, what happens in your brain and you're stressed, and you have these high anxiety situations, and it's releasing all of these things, your adrenal glands, and it's a high stress situation. And people have to make life or death split-second decisions when they're going through these things. He told us how a person perceives time differently. That something that was a second may have actually been a minute. And he told us that if someone's older, or if they have prior negative dealings with somebody, all of those things can affect their decision-making. It's very difficult for someone to judge what is going to come next.
We're still counting curse words.
Susan Lorincz can defend herself to prevent the imminent commission of burglary, murder, or aggravated battery against herself. So this sort of lays out the definition of those things, and I'm not going to read it all again. But there's an important thing that I want to point out about the crime of aggravated battery. It's defined as intentionally touching or striking another with a deadly weapon, or intentionally or knowingly causing great bodily harm, permanent disability, or permanent disfigurement to another. We heard from Dr. Norford, the medical examiner in this case. In our cross-examination, she told us, yeah, I mean, if somebody is hit or kicked or punched, and that person is older, and they have medical conditions, that could cause great bodily harm to them. So if Adjika Owens gets through that door and just punches or kicks or hurts Susan Lorincz, that could cause her great bodily harm. We heard the statement that Susan Lorincz gave to law enforcement. We heard two of them. And Miss Lorincz told detectives on the night of that incident she was pounding, Miss Owens was pounding on her front door so hard the walls were shaking. She told detectives that Miss Owens was screaming at the top of her lungs and that Susan told her, "You're trespassing, you need to leave." Susan Lorincz told detectives, "I really thought she was going to break my door down. I really thought that. I saw the door moving in, and I really believed that. I honest to God believe that." That is what she said. She reasonably believed that. We heard Susan tell the detectives, "I heard Miss Owens say, 'I'm going to fucking kill you.'" She heard that. Miss Lorincz told them, "I heard the door crack. And when I heard that door crack, I fired." We heard from Joshua Wright, the ballistics expert, and he sort of worked in conjunction with Toby Terpstra, and they created this 3D visualization that you saw. And what's important about Mr. Wright's testimony is that it's consistent with what Susan Lorincz told detectives. I was standing back near the table. There's no evidence that she moved this shell casing or did anything like that. It's consistent with what she told them. Miss Lorincz told them, "I wasn't going anywhere near that door. I was terrified it was going to come down." And he told us, yeah, it's pretty likely that Susan was standing by her table when she fired the gun. So how do we decide whether somebody is justified in using deadly force? And this paragraph sort of guides us in that, and it tells us that you must consider the circumstances at the time the force was used, all of it. The fact that she's in her home, she's alone, it's nighttime, her knowledge of Adjika Owens and her past interactions with her, the noise level with the pounding and the screaming of the profanities, the problems that Susan Lorincz was having physically, all of it. You have to take into account those circumstances. It's what she would reasonably do. The beauty of the law is that it does not punish individuals that reasonably perceive that danger. Now let's talk more about that danger, because the law goes one step further and it tells us that the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. And we know that it was real to her because we heard her in her statements to detectives. I really thought I heard that crack and she was coming through that door. She just believed that. And if she believes that and she perceives a danger and that danger is reasonable in her shoes, she can defend herself. She does not have to wait. So was it reasonable for Susan Lorincz to think that she was in a dangerous situation where she could be hurt or killed? This is what was standing between Susan Lorincz and Adjika Owens on June 2nd of 2023. Adjika Owens was a 35-year-old woman who was 5'7", weighed 293 pounds, and was very, very angry at Susan Lorincz. A door frame that was broken and barely hanging on. Now we heard from Charles Gabbard. He told us, I tried to fix this door as best as I could. I put some screws in it, put some putty in it, and it was structurally sound. He made a point to let everybody know it was structurally sound. Not really sure how he knows that. He didn't really do any testing. But he wants everybody to know this is not my fault as a landlord. That door was structurally sound. But it doesn't really matter whether it was or it wasn't. What matters is that Susan Lorincz knew the shape of the door and what it was like on that day. And she believed that door wasn't going to hold up. And was it reasonable for her to think that? Absolutely. All we have to do is look at the photos. The crack goes all the way down the frame. Almost all the way down. Was it reasonable for Susan Lorincz to hear a crack when Adjika Owens was banging so hard on that door? Absolutely. Miss Owens was a woman who ignored not one, see the no trespassing sign in the window, not two, but three no trespassing signs. 3. And we know this was not the first time that Adjika Owens had trespassed on Susan Lorincz's property, and we'll get to that a little bit later on. Miss Owens was very, very angry. How do we know that? What evidence tells us that? We know that there was an interaction that Susan Lorincz had with Adjika's sons, Israel and Isaac. Susan talked a little bit about it in her statements to detectives. There was an issue with a tablet and a pair of skates and an umbrella. And Miss Owens went over to confront Susan Lorincz about it, and we heard from Yaro Rodriguez, and he took the stand and he told us, Miss Owens was mad. Yaro Rodriguez told us Miss Owens' tone was a loud and a mad one. He told us Miss Owens was screaming and using words like bitch and fuck. And he told us, at first he didn't admit it. He was like, I didn't see her knock on that sliding glass door first. But we reminded him, you gave us a deposition and you told us about these things. And he said, yes, actually, I did remember. I did see that. So she went straight to this sliding glass door and she started pounding as hard as she could. And we heard from Jareth Gardner. And he told us that he was over by the basketball hoops, and when Isaac and Israel came up to him and told him something that had happened at Susan's house, and he told us one of the kids said, go get AJ. He didn't really want to tell us, but he admitted, yeah, she seemed frustrated, Miss Owens seemed frustrated, and that he heard Miss Owens knocking, and then knocked again, but this time it was louder. He told us that he heard Miss Owens say, bitch, open the door. And he told us that Miss Owens' demeanor was like somebody had just messed with her kids. And he told us that even he started walking over to Susan Lorincz's home because he felt the energy and he knew an altercation was about to happen. This was not a woman that was coming over to have a nice chat with Susan Lorincz about what had happened with her children. We cannot ignore the realities of what happened that night. the state may compare this to someone just coming on to the little, come on, Susan, I want to talk to you about what happened with my kids. That is just not what happened. Miss Owens was screaming so loudly that Rosalie Smith, a neighbor that lives a football field away, heard her. She said it was so loud. So if you can imagine how loud it was for Rosalie Smith, who was a football field away, imagine what that felt like for Susan Lorincz, who was right on the other side of that door with that broken door frame. Ms. Smith told us it wasn't just 3 bangs and then another 3 bangs. She told us it was a lot of pounding. I mean, a lot. And that it felt like even to her, it went on forever. Yariel Rodriguez told us Miss Owens was banging on the door hard, and she was banging with her fist. I mean, he told us this is what I saw, and that she was banging in the middle of the door. And we heard from a really important witness, Yvonne Costa. The state called her as a witness, and that's Susan's neighbor that shares that wall with her. And she told us that all of a sudden, she heard a banging that was really, really bad. I mean, so bad even her walls were shaking. So bad that she was scared. So it's not just Susan Lorincz saying, man, that banging was so loud, I was scared. Her neighbor says, I was terrified. That's how hard it was. She told us that the banging stopped, and then she heard it again, and then at this time it was even worse, and that there was a lot of it. A lot of banging. Not just 1, 2, 3, 1, 2, 3, a lot. She told us that while she heard the banging, she heard voices. Loud, aggressive, very guttural and deep voices, and that it sounded like it was coming from outside. Miss Owens was angry. And if she got through that door, and Susan Lorincz thought that she was going to because she saw it moving in and she heard that crack, she was in fear for her life. Adjika Owens was trespassing on Susan Lorinc's property. And Susan Lorincz was in her home where she had a right to be, and she had no duty to retreat. She had a right to stand her ground and defend herself because she was reasonably afraid. Now, the state may say, well, Susan Lorinc's fear, that wasn't reasonable because Adjika Owens never got through that door. She didn't go over to Susan Lorinc's house to harm her that night. She just merely wanted to go onto her porch and talk to her. They may say, well, did she trespass? Maybe. But she never intended to harm her. But the law on self-defense accounts for situations just like this. Situations where someone unlawfully and forcefully comes onto someone else's property. The law tells us, hey, there are certain circumstances where if certain things happen, you can presume that someone has a reasonable fear. If certain things happen, you can presume that the person was going over there to cause harm. And these next 2 slides, they deal with that portion of the law. And we sort of have to read these in conjunction with each other, and so I want to go over the definition of dwelling. And this is something that Mr. Buxman didn't talk about, and this is really important. So dwelling means a building or conveyance of any kind, including any attached porch. Whether the building or conveyance is temporary or permanent, or mobile or immobile, which has a roof over it, including a tent, and is designed to be occupied by people lodging therein at night. So remember that includes any attached porch. So when we go back and we're looking at this,
this is important for the law.
The person against whom the defensive force was used, aka Miss Owens, was in the process of unlawfully and forcefully entering, or had unlawfully and forcefully entered a dwelling. So a dwelling includes an attached porch. So did Miss Owens unlawfully and forcefully step onto that porch? Absolutely. Not the door. We don't have to wait for her to get inside the actual house. The patio is part of the house.
It's part of the dwelling legally.
So did she unlawfully go there? Absolutely, she was trespassing. Did she forcefully go onto the porch? Absolutely. How do we know that? Yariel Rodriguez, Jareth Gardner, Rosalie Smith, Yvonne Costa. She's yelling. She's angry. She's loud. She's banging. That's forcefully. That's what makes this different from someone like an Amazon driver coming to deliver a package. Miss Owens forcefully went on that attached porch, and that's the dwelling. And if that's the case, we have to presume that Susan Lorincz had a reasonable fear, because the law tells us that we have to. If that's the case, we have to presume that Miss Owens was going over there with the intent to commit an unlawful act. We have to presume that. We don't get to guess that. Well, maybe she wasn't going over there, she was just trespassing. No, the law says if she unlawfully and forcefully entered that attached porch, we have to presume she was going over there with the intent to do harm to Susan Lorincz. This slide is really important. If you find that Susan Lorincz, who because of prior threats or difficulties with Adjika Owens had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Adjika Owens, you may consider this fact in determining whether the actions of Susan Lorincz were those of a reasonable person. So let's talk about those prior incidents that we heard about. So Deputy Coleman testified. The state called him as a witness, and he told us, yeah, I went out there in February of 2022. And he told us, Susan Lorincz told me that Adjika Owens had battered her with the trespassing sign, hit her in the leg. And Deputy Coleman spoke to Adjika Owens, and he told us that Miss Owens told him, my dog likes to defecate on Susan's property. That's his favorite spot, and I don't care. That's where he's going to go. And unless she can show me a deed or something other than that, that's where he's going to go. Deputy Coleman talked to Miss Owens about this interaction that she had with Susan Lorincz. And Miss Owens again told the deputy, yeah, I told her I don't care about your sign. I can go get myself a sign if I want. I don't care about it. And she admitted to Deputy Coleman, yeah, I threw the sign. Deputy Coleman told Miss Owens, look, even though she's renting, that is not public space. That is private property. You cannot go over there. If you have an issue, call us. Coleman told us that he saw a red mark on Susan's leg, but despite that, he never arrested Adjika Owens. But we heard from London Remy, though, right? She was there and she saw this. She told us, I saw the sign hit Susan's leg. I mean, it barely hit her, but it hit her. For whatever reason, deputies decided not to arrest Adjika Owens. Deputy Coleman told us that Susan Lorincz had taken a photograph of Adjika Owens when they were having this confrontation. And this was entered into evidence, and it was stipulated to that this is the photo that Susan Lorincz took of Adjika Owens on February of 2022. Now, we also heard from Shelby Kinsey, and she was another deputy that had responded out in December of 2022 because of another altercation between Adjika Owens and Susan Lorincz. And Deputy Kinsey told us, I spoke to both Susan, I spoke to a mother, didn't even get her name, but spoke to a mother. We later learned it was Miss Owens, and Miss Owens told Deputy Kinsey, yeah, my 9-year-old son was mouthing off to Susan Lorincz. Miss Lorincz had told Deputy Kinsey that Miss Owens came to her house, knocked on her door, and said, if you treat my son like this again, I'm going to rip your ass out of your house and beat you up. Again, on that night, Miss Lorincz told Miss Owens, you are trespassing. Please leave my property. But Miss Owens didn't leave again on that night. She said, I have my son here, and I'm just going to talk to you about what happened. Susan Lorincz said, get off of my property. And when she felt threatened, she called the police, and that's when Adjika Owens left. Deputy Kinsey told us that Miss Owens herself said, Susan told me I was trespassing. Leave. I didn't leave. I wanted to talk to her about what happened with her and my son. Deputy Kinsey told us that Miss Owens herself told her, I said to Susan, if you walk up on my sons again, you're going to have to deal with me. Those were Miss Owens' own words. Once again, Miss Owens wasn't arrested, and Deputy Kinsey told her, you can't go over there. If you have an issue, call us. In her statement, Susan had told detectives about another time that Miss Owens had followed her a couple months before this incident, where she was like a foot behind her and she was following her almost all the way into her house. And that's the reason why Susan Lorincz had all these no trespassing signs up, members of the jury. She just didn't want people on her property. Now, this slide and this part of the jury instruction sort of deals with that same premise of if there's prior interactions between Miss Lorincz and Miss Owens. And this talks about if you find at the time of the alleged manslaughter by use of a firearm, Susan Lorincz knew that Adjika Owens had committed an act or acts of violence, you may consider that fact in determining whether Susan Lorincz reasonably believed it was necessary for her to use deadly force. Now, Mr. Buxman said, well, threw the sign, hit Susan Lorincz in the leg. London Remy told us that it did, but who cares? It was a flimsy little sign, no big deal. Maybe it's not a big deal to him, but it could be a big deal to Susan Lorincz as she's experiencing a traumatic situation, and it's something you have to take into account, and she knew that she had been previously battered by this woman. It was a big deal to her, to Susan, and that's what matters. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Susan Lorincz and Adjika Owens. Why does the law do that? Because it recognizes that a 35-year-old, 293-pound woman is much more dangerous if she gets her hands on a 58-year-old woman with the physical problems that Susan Lorincz had on June 2nd of 2023. Adjika Owens has much more capabilities, and Miss Lorinc's medical records are in evidence, and you can take your time when you're deliberating and you can go through them and look at all of those things. And we heard Susan talk about all of the medical conditions that she was suffering from when she spoke to detectives about her cervical fusion and her bad knees, and her knee going backward, and all of those things. The law says you have to take those things into consideration.
She didn't mention the torn rotator cuff.
I want to play this visualization for you one more time, but as you're watching it and as it transitions into the part where Susan Lorincz is in her home before she fires, I want you to focus on the door.
They spent a lot of money on this little video. So right here, you're in the dwelling, because that space is considered dwelling. Now, the state asked, I believe it was Mr. Smith, they asked Toby Terpstra, you took some liberties with making this video. That video was created based on Susan Lorinc's statement to detectives, where she told them multiple times, I saw that door coming in. I saw that door moving. She says that multiple times throughout her statement. That is what she said. So you can imagine how she sees this door moving the way that it is, and she knows that the door frame is damaged. How scary that must have been for her. And she had a split second to make a decision whether or not to fire her weapon. Florida law does not require it to be covered to be part of the
Susan
dwelling. It just has to be enclosed as far as fence, and it was.
They did a pretty big deal about, she asked about her cats. They asked another witness, how did she seem? She's like, well, I mean, I don't know. Is it really that unreasonable for someone as a pet owner who has two cats to just say, hey, can you just close my door so that my cats don't run out? Because she asked that question, that must mean she wasn't in fear. Now I want to address this. This is my only chance to speak with you, and Mr. Buxman may get up and speak, or he will get up and speak after me, so I want to address this just in case. In her interview, Susan Lorincz, they asked her questions about her researching Stand Your Ground on that second interview from June 6th of 2023. But if we go back and we remember, During that June 3rd of 2023 interview, the detective says to her, the law says it has to be imminent. And he's explaining to her sort of the law, and she's like, okay. Is it reasonable for someone to leave that interview and go and research? Like, man, I wonder what the law really says about this. Is that reasonable? Absolutely. The state argues that Ms. Lorincz knew that law enforcement was on the way, but we know it took law enforcement almost 15 minutes to get there. 8:54 is when she called 911. First officer didn't respond on scene until I believe it was 9:08. A lot can happen in 15 minutes, members of the jury, when you are in fear for your life. A lot. One of the last times the police came out, when Susan Lorincz told them that she had been battered, they didn't even ask Adjika Owens her name. The state says it's only 2.5 minutes. Only 2.5 minutes have went by. But Dr. Bedard, he talked to us about that perception and how that can feel like a very, very long time. And the state introduced some videos that Susan Lorincz had taken earlier in the day, and they had introduced this umbrella, and they introduced these skates. Even Mr. Buxman in his closing admitted, like, none of that even really matters. But they took the time, they introduced those things. Why do they do that? Do these skates, the umbrella, these videos, prove to you in any way that Susan Lorincz wasn't reasonably afraid? Because remember, they have the burden to prove she wasn't acting in self-defense. During the trial, Mr. Smith made it a point to ask some of the witnesses, particularly our expert, Joshua Wright, did you see there could have been gunshot residue on the door? All the stuff about the gunshot residue. Did their crime scene tech ever test the door for gunshot residue? Did you ever hear any of that? It took law enforcement over 2 weeks to even go out and collect that door and place it into evidence. And by that time, Charles Gabard had already got his hands on it, sanded it down, filled it in, painted it over, before they even collected the door and placed it into evidence. A door that they made it a point to ask the witnesses, was there any dents, any scratches on it? Waited 2 weeks after Charles Gabard had done work to it to even collect it. So I want to talk to you just a little bit, and I'm almost finished, about the state's burden. And I want to show you a little bit about sort of how that means, or what that means. If you are anywhere along this chart, other than the red part at the bottom, you have to find Susan Lorincz not guilty.
This is an effective chart.
If you think it was self-defense beyond a reasonable doubt, she's not guilty. If you think,
thank you, TC.
Man, this might be self-defense,
Hello
that's
to
not
Down
guilty.
Under.
Even if you think it probably wasn't self-defense, that's not enough. She's not guilty. It's not until you get down here where they've proven to you beyond a reasonable doubt that it was not self-defense. That is the only way that you can find her guilty, because the law says so. Now, this is the verdict form, and this is what you're going to see when you go back there to deliberate. And based on all of the facts and evidence, when you get back there and you're deliberating, we're going to ask you to check that box B. The defendant is not guilty. Thank you.
Mr. Buxton, can you and Ms. Sizemore approach real quick?
Defense is done. Fifth Judicial Circuit, State of Florida. That is one of the lamest seals I've ever seen. I'm sorry.
A very short break, and then Mr. Buxman will have his concluding statements to you. Then we'll go from there, okay?
Okay, let me make sure we're all the way caught up. Okay, now we're all the way caught up. So give us just a minute. We will be. They're still on break, but we're live. I love that we're seeing the IP addresses. It makes any technical work needed to be done a lot easier if you know the IP addresses of everything. So there we have courtroom 2A, IP 10.31.141.72, an IP address, 10.231.203.21. Yeah, you don't broadcast your IP addresses. I mean, once you're on this network, it's nice enough, easy enough to find. Saw a couple comments from people who said defense had a good closing. Defense did a good job. They introduced when they phrased it in a way that that I can see reasonable doubt there. I can see that now I'm not so sure. Let's see if we can give Thal a moment on the air. I think I know what he's going to say. Thal, let me guess. You switched, and now you believe she's guilty.
No, I'm not guilty. I'm not guilty.
Okay, just kidding. Yeah. I will say this. We've said this before. Florida is one of the friendliest states, and the laws are written the broadest in the United States. One of them for self-defense, meaning, and Utah's another one that's right up there. That if you're in a situation where you can reasonably, fear for your life, lethal force is justified based on the law. And the hang up here is that it has to be the reasonable part. And did they, was it a rational fear? It doesn't have to be an active presence. It doesn't have to be like a legitimate. And I think the prosecutor, when he used the example of, if I'm coming at you with a fake gun and you have the deputy has a real gun and shoots me, that's not a legitimate. If you threaten something and you don't see it, and you say, hey, I've got a pew pew, and I'm gonna get you type thing, and you don't have one, I think that's the same situation. What do you have to say?
Well, it's the same thing. It's like I told you in chat. If I'm banging on your door, and for reference for the chat and everybody else, I'm 6 foot 300 pounds, so I'm 6'1". But anyway, the thing is if I'm pounding on your door and you know how big I am and you've had history with me, and we've had an unpleasant history, you know how violent this could get, because I'm a big dude. Yeah. So, and if you're the size of that little old lady, you know what I mean?
I think that part's deceptive. First of all, she looks much older than I think she is, and jail can do that to you. But she's lost a ton of weight in jail, and size-wise, there wasn't a massive difference between the two at the time this happened. So if we're looking at her with their cardigan on, under hair, that's clearly it's going the color that all our hair seems to go nowadays. It looks different than the actual time. You look back to the photographs that were taken during that time period, and she was a heavier lady, and size-wise I think there were 8 pounds difference or something. It was something really close.
Yeah, well, and the thing is too, as I was about to follow on to that thought. It really doesn't matter anyway, because the thing is that if you're banging on my door and I've had history with you, regardless of your size, because I was going to say it also could be this, because that's not what the law says. It doesn't say if you're bigger than me, then I have a right to it. You know what I mean? It's not what it says. But the thing is that if we go by what it says, if you're banging on the door and you're screaming and I have history with you, you're not there to give me tickles and hugs.
And
I already know what you're gonna. I know what you're after, regardless if you damage the door or not. That's what I found about the DA said. That I was like, dude, it doesn't matter. It doesn't matter.
The state did a better job explaining that than defense did. That you can consider all the precursor stuff leading up to this as to the state of mind for the defendant. You can consider that. Defense didn't cover that very well. I mean, they said what happened, but the state put it all together and said in that moment to make just look and see if this is reasonable. You can consider what led up to the threats that there have been before or that have been alleged before. There's room here, and this is a Florida jury, so anything can happen. But I think
and the other thing is, too, is we have a clear line of escalation of behavior between the two of coming over and screaming, the sign throwing. If the jury thinks that there's a clear line of escalation between the two, then at some point you're going to get assaulted.
We have the banging louder.
That's what everybody would.
The first banging and the banging louder, the yelling. Even if there was no threats, there is some escalation there. Florida law, the way it's written, as soon as she stepped past that little gate in the fence, even though it was open, that's like an enclosed area, just like an enclosed yard. That's considered part of the dwelling. And then, the way the law is written, and it's a fine line here. It's a very thin line. But there is room, I think, for a jury member to look at this and say, yeah, I mean, I don't think she did the right thing, but legally she might be covered.
Well, see, the thing is, in Nebraska, I know that there's no stand your ground in Nebraska. So you have a duty to retreat at all times in the state of Nebraska, unless it's the only place you don't is inside your house or on your property.
The judge just
cold here today.
Gave the most awful sigh of my life.
You doing a second one, or is he doing both?
Oh,
okay.
I'm sorry.
No, I didn't.
He went, oh, as he was sitting down on the bench.
You guys don't remember the day when the
That
state
was
sometimes
terrible.
was in the middle? I do. And then the
Poor guy.
Okay, as always, Saul, we got to cut you off because the
Like
judge
when
is
you were
here.
in county court, you didn't know it was going to
All right,
happen.
brother. I think we're going to hang up. I think we're going to end up with a hung jury, though.
Awesome. Thank you, Paul. Appreciate it.
Good. Bye.
Bye.
Which really just meant splitting your one closing in two and doing it that way. But let's go back on the record. I see Miss Lorincz is back in the courtroom. And are we ready for the jurors, everybody?
Yes.
Okay. When I finish reading, I will, as I usually do, ask, is there any objection to the instructions as read?
And Judge, there was a couple words that you messed up.
Okay.
So I don't really necessarily want to say that in front of the jury, so you want to just wait until they're taken out?
Tell me now, and I'll reread it.
I don't really think that it's necessary. I just didn't know that.
I just want to point out you made a mistake and get it on the record. I'll have to fix it.
Which word?
We're going to do a poll.
If you have an objection, I need to address it now, and I'll re-instruct.
I have no objection.
But if you want me to reread, is it like something?
I think you just said when there was, in the word injury, you said harm, and then you're talking about the capacity, I think you said something different. But it doesn't matter.
Capabilities as opposed to capacities?
Yeah.
That's highly possible. Where is that? In justifiable use of deadly harm?
You have no lesser included on this, so that it's just going to be guilty, not guilty, and hung jury.
For the capacities one?
For which one?
Are you asking about the capacities one?
Yeah.
Yeah, it's in justifiable use of deadly force under when you're talking about
Poll is
the
up.
physical capabilities between the two.
So I said capability as opposed to capacity.
Yes, I believe so.
I can reread that if you'd like me to.
You reread it, Judge. I don't have an objection.
I mean, they have almost the same definition.
Right.
Judge is going to reread it, I think, even though she's not objecting.
Seems like capability is more appropriate anyways, but I don't know what capacity means. But if I said capabilities, if you want me, and I may have, okay, I have no question. If you want me to reread that, I'm happy to reread it. If you don't want to reread it, let me know.
I don't think you need to reread it.
Okay, so you do not want me to reread it?
Correct.
Okay, so the two words are basically interchangeable, more or less. So if anyone wants me to reread it, I apologize for misreading a word. If anyone wants me to reread it, tell me now. If not, then I'll
Judge wants
consider
to
it waived.
reread this, please.
All right, so I'll consider it waived. And we'll bring it back, and I'll try to make sure I enunciate each word more clearly.
Every time he gets up and that chair just adjusts that air ride, I get jealous. Cherie, 1:20 a.m. Interesting and compelling closing, but I still think she's guilty. Susan was the agitator each time. Thank you very much, Cherie. 5 months of support. Thank you. Thanks for staying up late with us. The first, well, I'd say closings are almost done. The state still has a rebuttal, which means they go first and they go last. They divide it up. They get the last word because they have the burden of proof. So we've heard from the defense. We will not be hearing from them again before the jury starts deliberating, at least not in the form of argument.
The jurors have returned. Mr. Buxman, you ready to proceed? You need the screen?
Yes, sir.
We're caught up. We're live.
You ready for it now?
Yes, sir.
This is manslaughter.
Thank you.
No lesser included.
I want to start by talking about a few things in the defendant's interview and the testimony of Roy Bedard, and then I want to talk a little bit about reasonableness and eminence. You heard in the defendant's interview, I think on one occasion, there may have been two occasions, in which she indicated that Miss Owens damaged her door in the past. Well, look at the evidence that we have before us. We know the first incident that happened in February of 22, Deputy Coleman came. There was no indication that the defendant reported any damage to her door, showed Deputy Coleman any damage to her door then. We heard about the incident from February of 2023, February, and Deputy Kinsey responded. There was no indication of any damage done to her door. During the interview, the defendant talked about that third incident where she went over across the street into the driveway and confronted Miss Owens about telling a neighbor that she was a crazy bitch. There was no explanation or no discussion about damage to her door at that point. You heard from Dr. Roy Bedard, and ask yourself, what did he add to this case? He's not a psychologist, he's not a psychiatrist, he is not a medical doctor. He spoke in generalities. He told you about various theories. He told you about the structure in the brain and the adrenal glands and how people make decisions and what happens in a stressful situation. His testimony boils down to the more imminent and severe a threat is to someone, and the less time a person has to assess the situation and process the data, the more error that creeps into the decision. I talked with him about the example, if I'm driving down the road, the person ahead of me slams on the brakes, I have to make a split-second decision. Do I slam the brakes? Do I swerve right? Do I swerve left? Or do I just brace? If I have a half second to react to that, the chances of me stopping or avoiding the threat is lower. If I have more time to evaluate and process the situation and assess my surroundings, the chance of me making a reasonable decision and a safe decision goes up. That's common sense. The threat, this perceived threat that the defendant indicated she had that day was not imminent. The threat, assuming you can even call somebody banging on a door and yelling a threat, was a threat that was coming from the opposite side of a closed, locked, deadbolted metal door. It was not immediate. It was not imminent. It was not about to happen. There was no threat. And the defendant didn't have a split second to make a decision. She had a period of time to make a decision. And she made a variety of decisions during that period of time. And that's kind of what I want to go over in this part of my closing. She told the detectives that she thought the door was going to break down, break in. She thought Miss Owens was going to burst through the door and kill her. We know that the defendant is prone to unreasonable degrees of fear. When she was talking in her interview about the sign throwing incident, she told the detectives, and then when the first time when she threw the things at me, she was just so horrible to me. I was like, I just had neck surgery. And I'm like, she could have really killed me. And I was just like, oh dear God, she was just violent. She is describing an incident where Miss Owens picked up a no trespassing sign, 8 by 10, with 2 little prongs that go into the ground, and tossed it at her as she was walking away. Is that reasonable to believe that that act could have reasonably killed the defendant? Of course not. And again, London Remy showed you how it happened, showed you that she tossed it. But she tells the detectives that she's like, Miss Owens could have really killed me. That tells you the reasonableness of her fear. And remember, we're looking at reasonableness through the eyes of an average, ordinary, everyday person. You heard about, and we talked about the incident, the second incident that Deputy Kinsey responded to. And Deputy Kinsey told you that she walked up and talked to the defendant. The defendant's first complaint was about the kids trespassing. And only after that does she explain or say that, oh, Miss Owens said that she was going to drag me out and whip my butt. It's interesting that she never mentions anything about that on the 911 call. She doesn't say, oh my God, I had to shoot through this door, this woman had threatened me in the past. She doesn't say that. She doesn't mention anything about that statement in either of her two interviews, despite talking to the detectives for hours. Ask yourself, how much of a role did that event play in the defendant's decision-making process to fire the gun through that locked, deadbolted metal door? Let's look more closely at the circumstances about what was going on that night and look at her own words to assess how truly afraid and how reasonable her fear was. Her first 911 call.
Yeah, the secretary's out there right now. I'm sitting for my head. I'm very scared.
It's a cell phone video from her phone taken 5 minutes before she makes the 911 call. That's what's causing her fear. That's taken moments before she calls 911. Ask yourself, is that a reasonable fear? That she's in fear for her life? That's not reasonable. So she tells the 911 operator that she is so afraid of these children, she's in fear for her life from these children. Does she run into her house, barricade her house that very moment? No. About 30 or 40 seconds before she calls 911, she's outside taking more video. But she just tells the 911 operator she was in fear of the children. Ask yourself again, is that reasonable? Her actions are completely inconsistent with somebody being in fear for her life from those children. Still the initial 911 call.
They just keep badgering me and badgering me. I'm just sick of this stupid.
Does that sound like fear of the children, or does that sound like anger?
Are you or anyone else in danger right now? I locked my doors.
She tells the 911 operator she locks her doors, so there is no danger. Those doors were still locked. That door was still locked and deadbolted when Miss Owens comes over. Now she says she was in such fear of these children, in fear for her life, based on what she told the 911 operator. But there's a chain up there on the door as well. Does she activate that chain? She does not. She doesn't add that third level of security. Why not add that level of security if she was truly in fear for her life from these children? She doesn't do that because she wasn't afraid. She was angry. If she's in such fear of this 9-year-old child, does she take the chair that she says that she places under the doorknob and put it there for added security? No. Because again, she's not in fear of these children. She's angry. She had to walk right by that chair to go to the bathroom, like she said that she was when the pounding and things started. So we know from her interview that when this pounding and yelling began, she was in the bathroom.
I don't think she was in fear of the
pounding
kids.
And yelling,
she might have been in fear
and
of
she is so afraid,
AJ.
She goes and washes her hands. She tells you that the pounding and yelling stopped. Like it would stop if somebody is banging on the door, come out, and there's a pause for the person inside to come to the door or to react or acknowledge. Then when there is no reaction or no answer to the door, the pounding starts up again and gets louder. That is the complete opposite of somebody who is trying to get into the house. Again, there is no evidence that Ms. Owens was trying to get into the defendant's house. If she wanted to, she had every ability to do so. But she's banging, come out, pause and wait, bang again. And then the gunshot happens. If she wanted to get into the house, why not shatter the sliding glass door? Why not continually bang Why not throw the body up against the door? None of that happened. We heard from Uriel Rodriguez, who said none of that happened. She was banging. And she was banging hard. State never tried to hide that, and I never tried to suggest otherwise. She was banging hard. As we talked earlier in my first closing, that the defendant is not required legally to retreat because she is in her own home. So in order for her to claim and argue self-defense, she doesn't first have to retreat. But her actions inside the house are relevant to consider the degree of fear, the reasonableness of her actions, and the imminence of this perceived threat. So what do we know? When the banging and yelling starts, she's in the bathroom. This is based on her own words in her interviews. She doesn't shut and lock her bathroom door to put up another barrier between herself and this perceived threat. Instead, she leaves the confines of that additional safe space and walks towards the kitchen, towards the door. Does that sound like someone who is afraid for her life? Of course she's not, because there's a big metal locked deadbolt door standing between her and the knocker and the yeller. In her interview, she admitted that the first words out of Miss Owens' mouth were, "Why do you speak to my children this way?" Not, "I'm going to kill you." I'm going to come into your house. Why do you speak to the children this way? When the yelling starts, she doesn't go find her phone that she had 2 minutes earlier when she just hung up the phone with 911 to call again. Instead, she goes to the bathroom to wash her hands. Ask yourself, how truly, reasonably terrified is she? The banging starts up again and she goes to her bedroom. She grabs the gun from her bedroom, and she doesn't grab the .22, the Ruger, the little plinker that she called it. She grabs the more powerful .380 Remington firearm. She doesn't shut and lock her bedroom door where she is with the gun to put up another barrier between her and this perceived threat in case by some chance, if she truly believes that Ms. Owens is going to come into her house, now she has another barrier to protect her. She doesn't do that. She doesn't walk around the corner and point the gun ready and waiting. No, she doesn't do that. Instead, she leaves the additional safety and security and that additional barrier that she could have put up and walks towards the door. Walks towards this perceived life-threatening threat. She says she walks up to the kitchen table, she raises her firearm, points it at center of mass, where a person would be, and pulls the trigger. One shot.
She said
not
center
a
of
panicked
mass?
flurry of gunfire, one controlled, precise shot, a kill shot.
A kill shot.
Ms. Sizemore
Kill shots are sideways, right?
told
Daryl
you
Brooks
that
taught
the
us that.
defendant, there's evidence that at the time, right before she shot, the defendant said that she heard a crack in the door. You will listen to both interviews and the 911 call. You look at the transcripts. If you want to listen to them again, you have every right as a jury to listen to those interviews again. Nowhere in those interviews does she say anything such as, "I heard the door breaking, I heard the door cracking before I fired." If you want to listen to them again, you have every right to do so. There is no wood splinters on the floor. There's no new damage to the door frame. There's no wood hanging off when the deputies get there and the crime scene investigators examine it. There's no evidence whatsoever to indicate that there was a crack before the gunshot took place. You heard from Josh Wright and Toby Terpstra. They collectively created the diagram as well as the digital animation. And using the diagram created by the defense, before we do that, Catherine Medina, there was discussion about Catherine Medina doing the trajectory analysis and how that she didn't calibrate certain things. Her role was not to do a full-blown trajectory analysis. She's told you she doesn't have the training and the experience to do that. Her goal was to create a general representation of the trajectory. And even Josh Wright said, based on what she did, it may be a little larger cone of error, but her job and what she did and her representation was a good representation of where the defendant would have been in the path of the travel of the trajectory of the bullet. But take the diagram provided by the defense as true. Who fires a gun like this? She's trained. She's gone to the range. She's practiced. I think in her interview, she said she's watched videos of how to properly shoot and things like that. She even demonstrated in her interview that she held the gun like normal people hold the gun. People don't hold the gun over your head like that. That's the representation provided by the defense. That is inaccurate. That's not reasonable. People don't do that. In order for the gun to be brought down lower, she has to advance closer and closer to the door to maintain that trajectory line. Now, ultimately, does it really make much of a difference where the defendant is standing in her house when she fires? Not really. Does it matter if she's standing right by the kitchen table or if she's standing a foot or two up or a foot or two back? Not really. It doesn't change the facts in this case. What's important about where she's standing is, assuming she's even standing where she says she was standing, what's important is after she gets the gun, she's approaching the door. She's walking towards whatever this life-threatening threat that she thinks there is. She's approaching that threat. That is inconsistent with somebody who is afraid for their life. That's, unless you're a law enforcement officer or military or firefighter, most people don't approach the threat. They don't run towards the threat.
Closing out the poll right now, it looks like about 60% of us are leaning guilty, 22% not guilty, 18%.
The video reenactment created by Mr. Terpstra.
Hung jury.
He admitted that that was based on the defendant's version of events. The video and the way he went about creating it, it was pretty cool. It was neat. But ask yourself, what does it add to this case?
Cost.
It shows Miss Owens banging on the sliding glass door. Well, we know that happened. Gabriel Rodriguez told you that. It shows the defendant, or Miss Owens banging on the outside of the defendant's door. Well, we know that happened too. It showed the defendant walking towards the door with her gun raised and firing a shot through the door. We know that happened. And it showed the shooting of the projectile, the bullet, through that closed door and hitting Miss Owens. We know that happened. Now, he took some artistic liberties by making the mirror shake and the door shake, and he did that on his own. He's basing it on the defendant's interview, but he decided how to make that happen and how to artistically represent that, to represent the degree of force that the defendant said she saw. That's not evidence. That's a representation of his artistic representation of what he thinks the defendant meant and what the defendant said she saw. Again, the video was cool, but it really doesn't add anything to this case. So after the shooting, we hear she makes the second 911 call. And we heard during the first couple minutes of that second 911 call, she's crying. She's upset. Of course she's crying and upset, ladies and gentlemen. She just fired a shot. She knows she shot somebody and realized the gravity and the implications of what her decision was. But notice how her demeanor changes very quickly during that 911 call when she starts talking about the children.
Something's trespassing over here. They're bothering me and bothering her. That's just not stop. See, the boys were here earlier. They keep leaving their garbage all around the house. Okay. And then I told them to take the crap away, get the stuff out of here.
That's after she fires and after the first initial minute or two of her crying. She's still angry on the 911 call. You saw Deputy Barbosa's body-worn camera when they first made contact with the defendant. That happened right after she hung up with 911. She wasn't hysterical. She wasn't bawling her eyes out. She was calm. She was cool. She was collected. I think she asked to go in and get water and asked for something to be done with the cats. And look at her demeanor within minutes of being placed in the patrol car. She's, again, not crying. She's not hysterical. This goes to the reasonableness of her fear. Deputy Welfenberg described her demeanor as indifferent. As I said earlier, ladies and gentlemen, the law requires the threat of death or great bodily harm to be imminent before deadly force is used. There was no imminence at the time she fired that gun. The word imminent is very important. It's included in the law and in the instructions for a very important reason. In order for the defendant to lawfully use deadly force, the threat to her life had to be imminent, had to be ready to happen, had to be staring her in the face, such that she had to act at that moment to protect herself. Now, some of the defendant's medical records were introduced, and there's no dispute that she has those medical records and she has some medical conditions. And if this was a situation where Ms. Owens broke down the door or broke that sliding glass door and was coming at the defendant, those medical records might be relevant because her physical ability to actually engage in a fight could be relevant to this case. None of that happened. Why? Because there's a big door standing between the two of them that couldn't be breached. The defendant knows what imminent means. You heard in in one of the interviews that she did, she gave an example to the detectives. She said, imminent danger is like when a 4-ton truck is coming straight at you and they are swerving with you as you try to run away. That's a very different situation than somebody banging on the outside of a secure door and yelling with no ability to enter. Ms. Owens is not a 4-ton truck. She was not coming at the defendant when the defendant fired. She was not swerving to try to get to the defendant as the defendant ran away. Ladies and gentlemen, the defendant didn't have a half second to process this. She had minutes to process this. All the decision making that we just went through in the beginning of this part of my closing, all the decisions she made, where she went, wash your hands, go here, walk around here, go to the trash can, grab the more powerful weapon, come and approach the threat and fire. And then she had the presence of mind to go back with the gun she just used to shoot and put it back in the trash can underneath the smaller .22 Ruger. Ladies and gentlemen, as a society, we do not condone shooting another person because of an act that may occur in the future, or because X, Y, and Z may happen, and I may be forced to defend myself. Law enforcement officers are not allowed to go around shooting people because the person may have a gun, may pull it out, may threaten the officer with it.
That's sustained.
Another rare win for the defense on objection.
The danger has to be imminent. Not it could happen. It may happen. If 2 or 3 or 4 things occur, it may happen. That's not imminent. The defendant does not get to shoot Miss Owens because Miss Owens may somehow manage to get through that door and may then decide to attack. Because before that door is actually broken in, Miss Owens has no physical ability to cause any harm whatsoever. That is the law that we have agreed to live by. Because there was no imminent danger when the defendant pulled the trigger, her decision to shoot and kill Miss Owens was not reasonable, and it was unlawful. We talked in jury selection that your role in this case is to determine whether or not the defendant's actions on the night of June 2nd, 2023 violated the law. It is not anyone's role here to determine if the defendant is a good or a bad person. And this decision that you're about to make should not be based on sympathy to Miss Owens, her family, sympathy to the defendant. Your decision in this case should be based on the law as the judge reads it to you and how the facts that you know that have been proven apply to that law. And as I said when I started this, the facts really aren't in dispute. Miss Owens is banging on the door yelling. She's angry. She's angry about how the defendant treated her children. Ms. Owens is not trying to jiggle the doorknob or break down the sliding glass door, break the window, not trying to get into the house in any way. Law enforcement was on their way. She gets her gun. She fires one shot, center of mass, which kills Ms. Owens. The judge will tell you that it's your duty to determine if the defendant is guilty of manslaughter. If you find the defendant guilty, it is his job to determine what the proper punishment or sentence should be, not yours. I submit to you that if you are back in the deliberation room talking about the case and you're thinking, what's going to happen if she is found guilty? You've already made your decision that she is guilty. because that's what the evidence has proven. After you boil down the facts and circumstances, you really have to answer one question, like I said when I started. Following the laws that we have agreed upon, is it okay to shoot through that closed, locked, deadbolted metal door as someone who was banging on it and yelling, but posing no imminent threat? Based on the facts of this case,
I'm not eating.
It's
That's
not
the
okay.
judge making mouth sounds.
Based on the law in this case, it's not okay. Just being afraid is not enough. Just her saying she's afraid is not enough.
My mic's muted when I'm not talking.
Using
That's
that
entirely the
ordinary,
judge.
average, everyday person standard, you have to ask yourself, were her actions reasonable? Was her decision reasonable? And was that threat imminent? Was it about to happen right now? Ladies and gentlemen, the facts of this case have proven her decision was not reasonable. The decision wasn't made while acting in necessary self-defense. It was not justified. Because of that decision, because of that unlawful decision, Ajika Owens lost her life. We ask you find the defendant guilty of manslaughter with a firearm, because that's what the evidence has proven beyond any reasonable doubt, and that's what the law requires. Thank you.
All right, we're starting a poll right now on jury deliberation times. How long will the jury
If you
deliberate?
listen carefully, have your final instructions, okay?
4 options.
Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2. Did the witness seem to have an accurate memory? 3. Was the witness honest and straightforward in answering the attorney's questions? 4. Did the witness have some interest in how the case should be decided? 5. Does the witness's testimony agree with the other testimony and other evidence in the case? 6. Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You have heard testimony of a child. No witness is disqualified just because of age. There is no precise age that determines whether a witness may testify. The critical consideration is not the witness's age, but whether the witness understands the difference between what is true and what is not true and understands the duty to tell the truth. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusation against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1. Whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2. Whether anyone had promised her anything in order to get her to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending on you to make a wise and legal decision in this matter. 2. The case must be decided only upon the evidence that you have heard from the testimony of the witnesses and has seen in the form of the exhibits and evidence and these instructions. 3. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the information or not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. Here, there is only one crime, so only one verdict may be returned.
We're going to get rid of the
The verdict must be in writing, and for
total.
your convenience, the necessary verdict form has been prepared for you. It reads as follows. It says right on it, verdict. Count 1, the only count. We, the jury, find as follows as to count 1 of the charge. In parentheses, check only 1 as to this court count. The first choice, A. The defendant is guilty of manslaughter. If you check A, you must then answer the following question. Did the state prove beyond a reasonable doubt that, during the commission of the offense, the defendant personally used a firearm? You'll check either yes or no. The other choice, B. The defendant is not guilty. So say we all, dated, this is the 16th day of August, 2024. This will need to be signed in pen by the foreperson, and then bailiff will have a pen back there for the foreperson to use.
There's no requirement whatsoever for the defendant to have said, I have a gun.
In just a few moments, you'll be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way, and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another, and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as an email or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. This includes any sort of like Apple Watch or anything else where you can get and send emails or make phone calls. Okay, you'll need to leave that with the bailiff. If you have an old-fashioned watch like me, you're fine. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items are received into evidence as exhibits. You may examine whatever exhibits you think will help in your deliberations. A, these exhibits will be sent to the jury room with you when you begin to deliberate.
Oh, they get exhibits
B,
as well.
if you wish to see any audio or video exhibits, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you don't like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Give me 1 second. Put my stuff together here. At this point, in just a few moments, you're going to go back to the jury room, okay? We'll have your lunch for you shortly. You can either eat lunch and then deliberate or deliberate through lunch. The choice is yours, okay? The evidence, the physical pieces of evidence that you can physically see and touch and look at, they'll be brought into the jury room for you. Electronic evidence, 911 calls, the recordings of the conversations and the statements, anything that you saw digitally on the screens, you'll need to request to come back out here to watch that, because obviously we have no computers in there for you to watch it. But send me a note, and then we'll bring you out here all together, and we'll all watch it. You can watch it as many times as you want. You can get as close to the screens as you want. The choice is yours, okay? There's no limit on your deliberations. You can take as long or as short as you need to decide this case. The final instructions that I just read, these instructions are for the foreperson. I have put the verdict form on the back of the instructions so it's easy to find. The other 5 copies are for the other 5 jurors. They don't have a verdict form, okay? The reason I said 5 is because 2 of you have been serving as alternates, and the alternates will not go back into deliberation. What's going to happen is you'll still get your lunch, but we'll have you
this judge is so worried about food.
Take that in another room, and then I'll discharge you after that, okay? The alternate jurors are, and remember your numbers, juror number 7 and juror number 8. If you are juror number 7 or number 8, I'm going to ask you, do you have anything left in the jury room? If so, please retrieve it at this time and bring it out here.
Get your eggs. Don't leave any notes to the other jurors in there as well. That's also not
The rest of you are not alternates. So as soon as they come out, I'll let you go back, okay? And give the bailiffs a few minutes. They'll bring in all the evidence for you. And they'll also bring in the instructions for you. Yeah. if you all would just wait there, the rest of the jurors, you'll go back to deliberate, okay? And we have the instruction for you.
I used to have a beautiful online counter on the website, Google, which provided it.
What I'm going to do is we'll have your lunch for you in the other room, and then when you're done with your lunch, we'll take care of you being discharged, okay? I'm going to ask you, even though you go home, not to look up anything about this case or discuss anything about this case until the end of the night, okay? Or if you hear the case is over. The reason for that is if something happens to one of these jurors, you could be brought back in to participate in deliberations. So I need to keep you as pristine as you are now, okay? So we'll take jurors number 7, number 8 to the other jury room, give them their lunch, and then you'll be discharged with my thanks. And I do appreciate it. Have a very pleasant day. The jurors have retired from the courtroom. Is there any objection to the instructions that I read?
No.
Did I mess up any words?
No, sir.
There was one error in there about the other trust. It's always one. But we're down to maybe one, so that's maybe progress. All right, so we'll be in recess until we hear something. Thank you all.
Throw the counter on the screen. We're very precise. This is an Olympic timer, so... We'll,
y'all look at the evidence going back.
Guess we're going to go to... Why are we not in 4? Oh, we want 4 to be 4. That's me. All right, timer's going. We are in verdict watch. I'm going to end the poll really quickly because the jury's out to deliberating. The question was, how long will the jury deliberate? I haven't ended it yet, so I guess technically these numbers are subject to change. Do we say jury watch or do I say verdict watch? I see Mountain Dew. Not anymore. You might see a couple more down here in the bag. How long will the jury deliberate? Verdict right after lunch today was 42%. Eat dinner and then give verdict, another 42%, so we've got a tie between the two. 84% of us think that it's going to be sometime today. Think about it over the weekend was 13%, and the final was I like jury duty, maybe next week, was just 3% now. So we'll end that poll and finalize those results for everybody. We do have Robert Tellis today. Yes, we do have Robert Tellis, and that's going to be starting, let's see, in a couple hours. Let me double check when we're starting. An hour, maybe? Or actually, just a few minutes. Yay! It's just in a few minutes. So we've got Verdict Watch going right here. We're going to keep that running somewhere. I don't know where I'm going to put that. I've got to get rid of that little... I need to use another window is what I need. So I'll have that... Let me go to channel 4 directly. Drop that out. I'm not going to have this on the screen. I'm down one machine, right? My mobile rig is one computer and one iPad less than I normally have. So I do have one call here as we get set up to jump over to the Robert Tellis trial. Let's see who's calling in. Ooh, it's from overseas.
Call from
Mattis.
It's Mattis. Mattis, are you there?
Yes. Hello. Is my audio okay for you?
Yeah, it sounds great. Sounds like you paid your phone bill.
Yes.
Does wonders for the sound.
I have to pay that.
What's on your mind?
I have a couple. Yeah. So I'm about to go to my parents' house and do dog sitting over the weekend. Mm-hmm. I'm going to spend a very nice, relaxed weekend with the 3 very lovely dogs of my parents. And I thought this was a great time to call in with some of my thoughts that I had. For this trial, I didn't pay that much attention to the law. Seems like there could be an area where you would have to acquit her, but I'm not
I didn't follow it that closely. But since we're starting Robert Tellis again, I want to comment on that. I very much agree that the prosecution gave a fantastic opening statement, and I want to comment on the defense. In a professional game, like let's say a card game, there's a saying that's called "play to your outs." That means when you're losing, and you know it's looking bad for you, think about what would have to happen for you to win, and then play as if that is going to happen, and what can you do to make it happen? And there's no other way you can win then that's exactly what you should do. And I think the defense is doing well, just not working because the outs are very, very difficult to do. But I think the defense is playing this correctly. But there's also another way you can do this, and that is a different trial that you didn't watch. And you commented on the opening statement. I agree, it was kind of jaw-dropping. So what I want to say is, once you have some spare time, I recommend that you watch at some point, let's say the prosecution's opening statement in the Chandler Halderson case, and then the judge's closing remark during sentencing. Because, spoiler, the prosecution wins that.
Spoiler
I think
alert, thank you.
that is another one. That's another case where it's just jaw-dropping how unlosable it is for the prosecution, given all the evidence. And for Chandler Halderson is another case where I think you have to realize you have to be nice to defenders, attorneys, because they don't get to pick their cases, and sometimes they're given the task of, okay, here's an unwinnable case. Please defend this as well as you can. And sometimes, if you're a good attorney, you just say, okay, no, I don't have cross. No, thank you. And that was basically the theme of that trial. So my recommendation is, if you want to see another like jaw-droppingly amazing prosecution opening statement, watch Chandler Halderson. It's about 1 hour, and then watch the judge's closing remark. Because he remarked, like, oh my God, this prosecution and investigation was so good. I think they put our county on the map, like nationally now. Everyone knows.
That's just how I felt about the Robert Tellis opening. That was so good.
Yeah. So that's my recommendation and I hope everyone has a great weekend.
Well, I will say this: when you said play to your strengths or play to your play to your outs or something like that. When I look at the defense and you say, yes, it is a difficult case and they should be focusing on the one way, all the pieces have to align for them to win. If you look at that cone of possibility for the angle of the firearm and where the gun had to be, that cone imagine that as the possibility of winning. It's very difficult for them to put all the pieces together and have it line up for the jury to say, yep, that meets the law. I can see it happen. If the jury looks at certain things and say, yes, well, that was inside the dwelling. That was aggressive. She did have fear based on there's a way to get there, but it's a narrow cone. And we'll see, this is a Florida jury, so they might do anything here. I mean, jury nullification at this point is still on the books. So.
Yeah, I think that the Florida case, it's a more recent, that case has a better chance of getting not guilty than your average trial. And especially, one thing that's going to matter is the demographics of the jury. Is it old or young? Is it male or female? Is it black or white? All of those factors.
And we don't know in this jury. I don't know anything about the jury at all. So we're just we've got a jury. We've got a Florida jury. That's about it. Mathis, it's very great to talk to you again. Thank you, my friend, and appreciate you paying the phone bill. I know it's not cheap to make these calls, but appreciate your insights on this. Hey, you're live if you're coming.
All right.
Okay. All right. We'll see you, Mathis. Thank you very much.
Bye-bye. Have a great weekend, everyone.
You too. Bye. All right. While doing that, I set up the thumbnail, the live stream for the Robert Tellis trial. I'm just going to make a portal that will get us over there because we're jumping straight from one to the other. Unfortunately, we don't have time to cover some of the documents which we have pending. We have a Sarah Boone letter. It's really a motion. We've got another call coming in. We've got a Sarah Boone motion coming in.
Donnie.
Is it Donnie?
Yeah, I had just 2 tacos, a large Sunkist Slurpee, and bread and butter pickles.
All right, that's going to be $15.73 at the second window.
Okay.
All right, thank you, sir.
Is that TV hanging on the wall? Did you hijack it up there, or did it come with the Airbnb?
It came right there.
Okay.
Donnie, love the not relevant, but it's good fun. All right, we've set up the portal to get us into the live stream, which has not begun yet. We just had a view of the courtroom wall. Do you need to run through again? I don't know. Mrs. Ari wants to run through or whatever. Because of that, we're going to leave the jury deliberating as they are. Let's see, let me put this up here instead. Move from one side to the. All right. Okay. So the jury's been deliberating for about 10 minutes. We're going to sort of keep an eye out for what's happening in the jury deliberation, and then we'll jump. So let me play the music and everything on this side and get ready to start Robert Tell Us, which I think starts like now. Hang on, we got Thal calling in. Just one second.
Call from.
Hello.
Thal, how's it going? You know I'm going to play the
Hey,
music.
buddy.
This is like the outro music that I'm playing for you. So you gotta sit down soon and stop talking. What's on your mind?
Yes, sir. Real quick, Ashley Benefield, a ex-lover, just dropped a letter to the judge.
Yes, we have that. I was going to say we've got Sarah Boone's motion. We have a couple. Ashley Benefield's trying to disqualify the judge. I think there's some other paperwork in there as well that was sort of all filed at the same time. It's spicy. It might have merit.
But nobody knows if it's real or not because anybody could have wrote it. So I was just making sure you had it.
Yeah, we've got it. We've got those filings. So we've got lots of stuff to fill in if we ever have a dull moment, which apparently this week we have not. So Boone has a motion and a response from JAC. We've got a lot to catch up on. So the jurors, Ashley Benefield has a motion about jurors and juror misconduct. That's in there. The dismissal of the judge. Lots of things to go on. But we're gonna play the music. Thals, you know what that means, right?
Yes, sir. It means hang up and run away.
Yes, it does. We'll be back in just a second with the Robert Tell Us trial. Thank you very much for joining us this morning, Thal. We'll catch you later, my friend.
See you, buddy.
See you. All right, as Thal hangs up here, we're gonna say tonight when you go home, please hug the people you love, smile at someone, make the day just a little bit better. Please stay safe. To go live again in moments. We're gonna portal you over to our coverage of the Las Vegas reporter murder, where Robert Tell Us is standing trial for the murder of an investigative journalist who wrote stories that were not favorable about him. Those stories may have had an impact on the voters because Robert Tell Us was not elected. He was voted out of office in his first re-election and was not happy about it. And then we have video after video after video that seems to point the finger at Robert Tell Us as being the person who lay in wait for the journalist and stabbed him to death in his front yard or on the side of his house as he came back from a trip to get tacos, I believe. So we're going to beam you over there. We've already got first in chat's already given away. I'm sorry, they were quick, but we'll be back over there in just a second. Court continues. We'll catch you guys on the flip side. Bye-bye.
My gosh, go down and fight them.